prefer that you can't make it that day at all?
No, I mean, I could do it by, I got like 4 cases in Oakland County Circuit. That's my bailiwick. I'm out in Pontiac.
All right. I can move it to put somebody on over there. Tell Heather to get on, will you please?
I'm on, Judge.
Okay, Lisa, is Judge Heston good on the 24th
Yes.
and July 1st?
Yes, both days are good.
So do you want your client, are those good days for you, counsel?
He just does it on Tuesdays, Judge?
Yeah,
Judge,
that's the only day the prosecutor's here.
now, is that going to be by Zoom or it'll have to be in person?
The exam will have to be in person. She'll let you appear by Zoom on the probable cause conference.
Okay. Can we do July the 8th, Judge? That's Tuesday morning. I'm free then, please.
Boy, you're going to have to talk to her. I can't move it that long. Can you not do the 24th?
Let's do the 1st, July 1st. I'll make it available.
You're asking for a lot here. I mean, we have to have.
Well, I'm just trying to see whether Tuesday I can make it by Zoom. No. I cannot do it on the 24th. I'm in trial in front of a circuit judge out in Oakland County for sure.
Is she good on the 1st and the 8th, Lisa?
Let me check.
You know what?
Those days are good.
Okay.
You could what?
I can do it on the 24th if I'm permitted to appear by Zoom.
Yeah. Okay. And then the 1st on the exam?
On the 7th, I'm free.
Pardon?
I mean, for the exam, I'm free on July 7th.
We don't do them on Wednesdays or Mondays. We do them only on
Tuesday. Okay, then I'm free on July the 8th in the morning for the exam.
Is she going to be okay with that, Lisa? I'm going to go ahead and do that. And, ma'am, you have the right to a probable cause conference within 14 days. You've heard about what your lawyer just told me. He can't make. The only way I'm going to grant that is if you choose to waive your right to a probable cause conference within 14 days. Do you understand that?
No, I don't.
Okay. Look, I got all these people here right now. You're going to have to talk to your client on Zoom or something, Mr. Weiner. I'm going to tell you this one last time, and then if you want, I'll be glad to let you go talk to your lawyer. You have the right to a probable cause conference within 14 days of today's date. Your lawyer says he's not available on the 17th. He's asking me to set it to the 24th, and then the exam on July 8th. If I do that, that means that the probable cause conference will not take place within 14 days of the date of the arraignment. You understand that?
No.
Okay. Well, you go talk to your lawyer, and then either way you come back in here. You don't listen to me very good.
Let me just say.
Hang on, Mr. Weiner. Today's the arraignment. Do you understand that? I explained to you your rights. Yes?
Yes.
You have the right to a probable cause conference where your lawyer is going to discuss this case with the prosecutor within 14 days of today's date. 14 days of today's date is on the 23rd. Okay? He can't do it on the 17th. He says he's tied up. He's asking me to adjourn it to the 24th. That would be 15 days from today's date. If you don't want me to do that, no problem. I'll simply set it for the 17th, and he's just going to have to be here or get coverage. Do you understand that?
I understand that.
Do you wish to waive your right to the probable cause conference within 14 days?
No.
Miss Nunnery.
Listen, I got 50 people here. I'm not going through this anymore. We'll send her to a Zoom. Either way, you have to come in front of me. We'll put you in front of a camera. And also make sure when you discuss it with her that she's going to have to waive her right to the exam within 7 days of the probable cause conference, okay?
Let me just ask her one question. Ms. Nunnery, we are not giving up the right to have a hearing. We're just postponing it. If that's okay, we're not giving up the right. We're just postponing it by 2 days. Okay?
That's fine with me, as long as that's what you say, I'm fine with that.
Do you waive your right to have the probable cause conference within 14 days?
Am I supposed to say, yeah, I don't know.
Okay, you guys go talk. I got too many people here to go through this any longer, counsel. I'm sorry. You talk to her, and when you guys are ready, I'll recall the case. I'll need that back here, John.
Okay.
Hidden Gardens versus all occupants, 2403440. Anybody here on that?
Judge, Miss Kingsley just logged back in. She lost connection. She's
Okay.
connecting now.
Is Miss Kingsley out there?
Judge, it just popped in. Miss Kingsley, can you hear us?
These are all for this afternoon. I believe those are for all the afternoon.
It looks like her audio is connected now, Judge.
Miss Kingsley, tell me your name, please.
Good morning, Mayor.
Good morning, Miss Kingsley. How are you?
I'm good. How are you?
Your parents?
Brianna Kingsley for the plaintiff.
All right. Is anybody else here on this case?
I've not had anyone else check in, Your Honor.
So when your other colleague was here last week, I don't remember who it was, or on the 19th of May, she was going to subpoena Gavin Thompson. I don't see Mr. Thompson here. This is all over the torn title. I know you're aware of the facts. He's not here. I read this again. I don't see any way I can do this in good conscience. The only thing I can tell you is unless you want to say something else and appeal it, that's fine. I'm gonna deny your motion, and I'm gonna suggest that you either file a bill to quiet title, or you can appeal, or whatever else you want to do. But I just cannot in good conscience grant this motion. And I'm going to state further, I still think Hidden Gardens, no disrespect, before they bought the property, should have made sure that all these titles were in order. That's my view on it. You can't have ripped up titles or gaps in title. We wouldn't buy a car without a title. And I understand what you're saying here. They transferred it over apparently, but it's ripped. It was never recorded. They're not going to accept it as it is. And I'm talking about the transfer of title to Mr. Gavin Thompson from Orla and Phyllis Miller. So I don't know what else to tell you. I don't think that you're either, in my view, either have to file a probate action and set up an estate, or file a bill to quiet title. You're not saying much, Ms. Kingsley.
It looks like we might have lost her. She must have bad connection this morning, Your Honor.
This is not going to be a good day, I can tell.
Okay, she understands, Judge. She's coming in.
I'm gonna go through this one more time with her, Mr. Weiner, otherwise you're gonna have to deal with, and I mean no disrespect to you, but I'm not gonna keep doing this, okay? Where is she? I'm waiting 30 seconds and then I'm going
sitting
on
in the
to
hallway,
other kicks. Well, what's she doing in the hallway? We wouldn't go to a Tiger game and sit in the parking lot. I'm going back to Hidden Gardens.
I'll have Will yell for her.
Why? I mean, why? Why? She knows where we are. She was just in front of me. Don't worry about it.
Okay.
She knows where she has to go. I told her she needed to come back in here.
I told her to, Judge. Let me.
I don't know what, that isn't her either. I'm going back to Hidden Gardens versus all occupants, 2403440LT. Ms. Kingsley, your name? I can't hear you. Do you want me to adjourn this, Ms. Kingsley?
He was looking for you.
Ms. Kingsley, where are you? Iron Mountain or what? Oh, this is the beauty of Zoom. Ms. Kingsley, I don't know what to do here. All right. I don't know what else to do. I'm going on to another case. Hamptons versus Jacqueline Terry, 2502034.
Morning, Judge. Robert Visconti, P61756 for the plaintiff.
Good morning, Mr. Visconti. Ma'am, your name?
Jacqueline Terry.
We adjourned this, right, to today. And you guys had, I thought, a preliminary agreement.
We did.
Oh, yeah, defendant left. I don't know how it happened, but at any rate, she was here. It looked like you guys had a consent judgment for 2804.62 with her to pay $1,400 by the 13th and the balance by June. I can't read my own writing. Is that the 20th?
June 30th. I believe it was the 30th, Your Honor.
Is that what you guys still want to do?
I'd still be willing to do that deal, Your Honor, yes.
Is that what you want to do?
Yes, that's fine.
Can you definitely pay that by the 13th?
Yes.
I feel a little uncomfortable with that. I'm going to just, unless you have a big objection, you want to tell me why, I'm simply going to move that to the 19th. Her first payment by the 19th and then the second by the 30th. Is that good with you?
Yeah, no objection, Your Honor. I understand that she would need 10 days under the statute.
Right. So, ma'am, do you understand and agree that you owe $2,874? Is it 2804? No, 2804.62, right, counsel?
Well, Your Honor, now it's there's a $70 late fee which has been added, so it's 2874.62, and I would just ask to change the first payment to 1470.
Oh, can you do that?
Yes, that's
Do you
fine.
agree that you owe 2874.62?
Yes.
Do you understand you have to pay this as follows: $1,400 by June the 13th, with the balance by June the 30th?
They told me the opposite.
I'm sorry, hang on, slow down. $1,470 by June the 19th, because I'm going to extend it to 10 days, and then the balance by June the 30th.
Yes, that's correct.
That's correct.
So you understand and agree to that?
Yes.
I want to cover that once more. That was choppy. You agree that you owe 2874.62?
Yes.
You understand there's two due dates. If you miss either one, you have to vacate. If you don't, you're going to be evicted. The first is on June 19th. You have to pay $1,470. If you pay that, you can remain in the property until the 30th, at which point you have to pay the balance. So if you pay $1,470 on the original date, then you're going to owe, it looks like, $1,404.62 by the 30th. Do you understand that?
Yes.
Do you agree to that?
I do agree.
Does Mr. Visconti have your permission to sign your name to that proposed consent judgment?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment, and you have 10 days to appeal. Do you understand that?
Yes.
All right. Any questions? All right, so Mr. Visconti is going to send that over. Just make sure you make those 2 payments as agreed upon, okay?
Thanks,
Best of
Judge.
luck. Thank you. Do you have any more?
I do, Your Honor. I have Heritage Square and I have Marian Manor. I also have 9 o'clocks with you, so whatever works best for the court.
All right. Is Miss Kingsley out there yet? I'm coming back to you in 1 second, Ms. Kingsley. Give me recalling Nunnery, Crystal Nunnery, 25R706963FY. And Mr. Weiner, your appearance again.
Earl Weiner appearing on behalf of Miss Nunnery.
Ma'am, your name again?
Crystal Nunnery.
Have you talked to your lawyer about this?
Yes.
Today is June the 9th.
Yes.
He can't make it on June 17th. We have our hearings on Tuesday. That's it. He's asking me to adjourn until June 24th. Do you understand that?
Yes.
If I adjourn to June 24th, that means that the probable cause conference will take place more than 14 days from today's date. You understand that?
Yes.
You have the right to a probable cause conference within 14 days. Do you understand that?
Yes.
Do you wish to waive that right?
Yes.
You also have the right to a preliminary exam within 7 days of the probable cause conference. If I grant that request and send the preliminary exam to July the 8th, that means that the probable cause conference will take place more than 7 days from the date of the preliminary exam scheduled date. So in other words, the 24th to the 8th is 14 days. That means that that would exceed the amount to which you are entitled to have your exam from the date of the conference. Do you understand that?
Yes.
Do you wish to waive that right?
Yes.
Anybody force you to do that?
No.
All right, so Mr. Weiner, we're going to do June the 24th at 10:15. I'll make a note waiver of 14-day rule, a 14-day and 7-day rule accepted. And those will be your dates, June 24th, 10:15. Make sure you go to AA twice a week, okay?
And
You
Judge, you're
understand?
allowing me to appear by
Ma'am?
Zoom.
Yes.
Okay. All right, thanks, Mr. Weiner. Have a good day.
Thank you, Judge.
Hidden Gardens versus all occupants, 2403440. All right, Ms. Kingsley, your name?
Yes, good morning, Your Honor. Brianna Kingsley for the plaintiff.
So I started to say before, I don't know when you could hear and couldn't hear, to say what I said again. On May 19th, somebody from your office was in here. I said, the only way I'm even going to consider this basically is if you subpoena Mr. Thompson. He's not here. I've looked at this brief again. I'm more convinced now that I was right than I'm right. I'm more convinced now that I'm right than I was even then. I just do not feel comfortable granting this motion under these circumstances. You're either going to have to go set up a probate estate, or you're going to have to file an action to quiet title. There's just no way I feel comfortable doing this under these circumstances. Again, I'm going to say Hidden Gardens, frankly, before they acquired the property, should have made sure that all these manufactured homes had titles that were properly recorded with the Secretary of State. So I don't know what else to do. I'm just going to tell you I'm dismissing the motion or denying the motion. Denying motion for disposition of mobile home.
I just want to say 2 brief notes for the record. The first note is that we did try to subpoena Gavin Thompson. Apparently he moved to Florida and nobody knows where he lives now in Florida. The second note is that Hidden Gardens as a policy does, when they have individuals sign leases, they do have a policy that they require them to provide a copy of the title in their name. So they have a
So they must have bought it after he was already on the property, right?
Correct. Yeah.
My only point is they should have made sure that all these people had properly recorded titles when they bought it, but that's neither here nor there. So I'm sorry. I feel bad for you. You guys got a mobile home that it looks like nobody's maintaining sitting on the property, but I just don't feel comfortable. So that's my ruling, and I'm sorry. Hidden Gardens versus Wesley Sprinkle, 2501951.
Brianna, for
Go
the
ahead.
plaintiff.
Where is
Judge, that one's not till 9:30. I think I had
Oh.
a note on it.
Oh, okay.
Sorry about that.
That's all right. It's not, why is it your fault? Okay, give me a rubber band. I'll come back to that one at 9:30. Heritage Square versus Jasmine Ethridge, 2502047.
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Is Jasmine Ethridge here?
Yeah, I'm here. I'm present.
Okay, good morning. Your name, ma'am?
Jasmine Ethridge.
All right. Did you listen to and understand the rights on the video, ma'am?
Yes.
Do you wish to speak to a lawyer?
No, I'm okay.
Do you intend to apply for funding?
No.
Counsel, why don't you tell me what is owed? You can just give me the total balance at this point.
Total balance inclusive of court costs, Your Honor, is $1,056.54 through the month of June.
All right, ma'am, you're going to be able to pay that.
Yes. When is it due by?
Well, it's the 19th. When can you pay it?
The 19th of this month, correct?
Correct.
I should be fine.
Can you pay it by then?
Yes.
Mr. Visconti, do you want to go into a breakout room with her and talk to her after your next ones are done? You have Marian Manor too?
I have Marian Manor as well, Your Honor.
Ma'am, why don't you stay right there? He's going to come into a breakout room and speak with you, okay?
Okay.
So we'll put you in a breakout room, and then when I get through these other cases, so we're not holding everybody up, I'm going to have him come and talk to you, all right?
Okay. Thank you.
Thank you. Marian Manor versus Jasmine Parker. Jasmine Parker, 2502049.
Robert Visconti, P61756 of the plaintiff. We're going to move for dismissal of that matter, Your Honor.
Case dismissed, motion to plaintiff. Marian Manor versus LaJacquil Peterson and Raven Morton, 2502050.
Robert Visconti, plaintiff.
I'm sorry, you cut out there, counsel. I need you again there.
Robert Visconti for the plaintiff, Your Honor.
All right, thanks. Mr. Peterson, your name, sir?
LaJacquil Peterson.
Good morning. Is Raven Morton here?
No, she will not be able to appear. She's on a family vacation right now.
Okay, so she's going to have to show up. I just want you to understand that going forward. Did you listen to and understand the rights?
Yes. Yes, sir. Yes, Your Honor.
Do you wish to speak to a lawyer?
No, Your Honor.
Do you intend to apply for funding?
No, Your Honor.
Counsel, tell me the total balance owed.
Total balance here, Your Honor, is $1,261.43.
Whoa. That's not what I was made aware of. I'm sorry.
Well, he's including the June rent now.
June rent was already paid.
Well,
I have receipts here. The office have already received it. They received it on the date it was supposed to be done, which was the 5th.
well, that would apply to the May rent though, right?
No, I have already. You talking about this will be paid of next month? This would be the rent due for next month.
This would pay you through June, sir.
Okay. I'm sorry about that.
It's okay.
I'm not understanding. Do you dispute that you owe this amount?
No. Now I understand. He said this would get me through June, so the month of June as well. Okay, I understand now. I was confused at first.
I'm going to let him go into a breakout room with you as soon as we're done, okay? Let me go through a few cases, and you guys see if you can work it out, and then you'll come back in front of me, so don't go anywhere.
Okay.
Marian Manor versus Destiny Marshbanks, 2502096. Marshbanks.
Robert Visconti, P61756 for the plaintiff.
Hello, Your Honor.
Good morning, ma'am. Your name?
Destiny Marshbanks.
Did you listen to and understand the rights?
Yes.
You wish to speak to a lawyer?
No, thank you.
Do you intend to apply for funding?
No.
Mr. Visconti, how much is it?
Your Honor, Ms. Marshbanks just made a payment of $1,326. That leaves her with a balance through the month of June, a total amount of $1,496.24.
Do you agree that you owe that amount, ma'am?
Yes.
When can you pay that?
Can you give me 2 weeks?
Yes,
Do you want to go into a breakout room with her?
sure. I mean, I could do a CJ for the 23rd right now, Your Honor, if she wants to agree to that.
So, ma'am, he's telling me that if you want to agree to a consent judgment, he'll give you until June the 23rd to pay. By law, you're entitled to 10 days. He's willing to give you an extra 4. Can you do that? I'm sorry?
Yes.
Do you agree to that?
Yes.
So you agree that you owe $1,496.24, correct?
Yes.
Your breakdown, Mr. Visconti, real quick, please.
So, Your Honor, I apologize because there was just a payment tendered. Why don't you go ahead and give us that breakout room?
No, that's okay. Listen, but you're not charging more than $70 a month.
No, the late fees are $70 per month. The court costs, Your Honor, are $176.54. If you give me a second here. So the rent to retain inclusive of the late fees would be $1,319.70. Court costs are $176.54 for that total of $1,496.24. And again, we do not charge late fees in excess of $70.
Okay, how much did you say the costs were again? I apologize.
$176.54.
So, ma'am, again, with the costs and the past due rent, you agree that you owe $1,496.24.
Yes.
He's willing to enter into or wants to enter into a consent judgment with you, which would be presented to the court for my signature. It would say that essentially that you have a judgment against you for $1,496.24 and that you have until the 23rd of June to pay that. If you fail to pay that, you will be evicted if you haven't vacated.
Okay.
If you pay that, you can stay in the property. Do you understand that?
Yes.
Does he have your permission to sign your name to that proposed consent judgment setting forth those terms?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
Any questions?
No.
Okay, so he's going to submit that. I'll sign it, and then it will be sent to you, okay? Just make sure you make that payment on or before the 23rd, okay?
Okay, thank you.
Best of luck. All right, Marian Manor versus Frowner. Elijah Frowner. And Janya Morgan, 2502097. Is anybody here with that name?
Hello.
You have to start your video, please.
I just turned it on.
There you go. Your name, ma'am?
Jania Morgan.
Good morning, sir. Your name?
Elijah Frauder.
Did you?
This guy for the plaintiff, Your Honor.
Did each of you, and I'm talking about you, Ms. Frowner, and you, Mr. Morgan, did you listen to and understand the rights, Ms. Morgan, on the video?
Yes.
Did you, Mr. Morgan?
Yes.
Do you either one of you wish to speak to a lawyer, Ms. Frowner?
No.
Sir?
No.
Do either one of you or both of you intend to apply for funding?
No.
Sir?
No.
All right. Mr. Visconti, tell me how much is owed without the breakdown.
Totals $2,381.40, Your Honor, through the month of June.
Do you agree that you owe that amount, Ms. Frowner?
Yes.
Do you, Mr. Morgan?
Yes.
Can you pay that amount?
Yes.
When can you pay it?
Is it possible we could pay on the 20th?
You don't have a problem with that, do you?
No.
So so if you pay by the 20th, so if he's going to want to do a consent judgment now, if you want to do that. And he's willing to give you until the 20th, which is one extra day.
Mm-hmm.
Do you want to enter into a consent judgment with Mr. Visconti, which would set forth a judgment amount in their favor against you in the amount of $2,381.40, with the understanding that you have to pay that on or before the 20th of June?
Yes.
Yes.
And you do too, sir?
Yes.
Does he have your permission to sign your name to a proposed consent judgment that would be submitted to me for signature? Again, setting forth those terms. Ms. Frowner?
Yes.
Mr. Morgan? Sir?
Yes.
Okay. Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that, Ms. Frowner?
Yes.
Mr. Morgan?
Yes.
Okay, so he's going to submit a proposed consent judgment. I'll get it today. I'm going to sign it. We're going to send it to you, but just know that you have to pay that amount on or before the 20th of June. Do you understand that, Ms. Frowner?
Yes.
Mr. Morgan?
Yes.
Okay, any questions, either one of you?
No.
No.
All right, I wish you well. Best of luck to you. Thank you very much.
Thank you.
All right. Just give me 1 second. All right. Marian Manor versus Ashley Sledge, 2502100.
Robert Visconti for the plaintiff.
Ms. Sledge, are you out there? Ms. Sledge, Ashley Sledge.
I don't think her audio is connected, Your Honor, but she is on Zoom.
Is that Ashley O'Neill?
No, she's wearing the Nike t-shirt.
Oh, there you are. Can you hear me, ma'am?
Are you able to hear me now?
Yes.
Yeah, get closer to the device and tell me your name, please.
Ashley Sledge.
Good morning. Did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
No, thank you.
Do you intend to apply for funding?
No.
Counsel, what have you got in terms of a total balance?
The grand total, Your Honor, is $2,451.54 through the month of June.
Do you agree that you owe that amount, ma'am?
Yes.
Can you pay that amount?
I'm expecting a bonus. In 2 weeks, I would have the full balance on the 26th.
Any problem with that?
The 26th would be fine, Your Honor.
So, ma'am, I want to make sure that you understand something. He's offering, I think, to enter into a consent judgment and give you until June 26th to pay. He would submit that to me. I would sign it. And that judgment would say that you owe $2451.54 and that you have to pay up or vacate on or before June the 26th. Do you understand that?
Yes.
If you pay up on or before that date, you can stay. If you don't, you have to vacate. If you don't, you're going to be evicted. Do you understand that?
Yes.
Now, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
Does Mr. Visconti have your permission to sign your name to a proposed consent judgment, which would indicate you owe $2451.54 and you have to pay it by the 29th?
Yes.
All right. Any questions?
No, I just want to say thank you so much.
You can thank Mr. Visconti. I wish you well. Just make sure you pay that by that date. Best of luck to you, ma'am.
Thank
Good
you.
luck. Thank you. Marian Manor versus Ashley O'Neill, 2502101.
Robert Visconti for the plaintiff.
I saw her. There you are, Ms. O'Neill. Good morning. Your name?
Good morning, Ashley O'Neill.
Did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
No, sir.
I'm sorry?
No, sir.
Do you intend to apply for funding?
No.
Mr. Visconti, tell me the total balance owed.
Total balance through June, Your Honor, is $1,096.16.
Can you pay that, ma'am?
I can pay some of it, like 500 and Wednesday, and I can pay the remainder balance on the 25th.
So how about, you said 500 by this Wednesday?
Yes.
And then the balance by the 25th?
Yes.
Mr. Visconti, if we write this up as 500 by the 19th and the balance by June 25th, are you okay with that?
I sure am, Your Honor.
So, ma'am, I want you to understand that he's suggesting, or at least you have the opportunity, if you choose to enter into a consent judgment with Mr. Visconti, and that would call for a judgment amount of 109,616 in favor of the plaintiff against you, with the understanding you're going to pay $500 by June 19th. If you do, you can stay until the 25th. And if you pay the balance owing on the judgment by the 25th, you can remain in the property. If you miss either of those payments, you have to leave. And if you don't, you're going to be evicted. Do you understand that?
I understand.
Now, does Mr. Visconti have your permission to sign your name to a proposed consent judgment?
Yes.
Since you're not represented by a lawyer, ma'am, you have 3 business days to come in here and fill out a motion to set aside the judgment, and you have 10 days to appeal this. Do you understand that?
I understand.
All right. Any questions at all?
No.
Okay, he's going to submit that order. I wish you well. Good luck, ma'am. Just make sure you make those payments. Thank you very much. Good luck.
Thank you. Have a good day.
You too. Marian Manor versus Trey Cox and Shannon Rivers, 2502103.
Robert Visconti for the plaintiff.
Do I have either of them? Shannon Rivers, your name?
Hi, my name is Shannon Rivers.
Trey Cox, your name?
Trey Cox.
All right, Mr. Cox, Mr. Rivers, did the two of you listen to and understand the rights? Mr. Rivers?
Yes, I did.
Mr. Cox?
Yes, sir.
Do either one of you or both of you wish to speak to a lawyer?
No, no, sir.
Do either one of you or both of you intend to apply for funding?
No, sir. No, sir.
All right, Mr. Visconti, I don't know if you stated your appearance on this. If you didn't, state it and tell me the balance, please.
Robert Visconti, P61756 for the plaintiff. Your Honor, the balance on this account through the month of June is $3,626.43.
You agree that you owe that amount, Mr. Cox?
Yes.
Mr. Rivers?
Yes.
Can you gentlemen pay that?
I can't, no. Not anytime soon, I don't think.
All right. Mr. Visconti?
Your Honor, I'd be happy to take a breakout room with these gentlemen, or I could offer at this point a consent judgment that would give them until June 28th, which is the last business day of the month, if they'd be willing to accept that. If not, I'd be happy to talk with them.
So you guys have two choices. You can either tell me, Judge, yeah, we're willing to enter into a consent judgment with the understanding we have to pay that amount by the 28th or vacate. And if we don't, we understand we're going to be evicted. Or we'd like to go in and talk to Mr. Visconti a little bit more about other options. You tell me what you want to do, Mr. Rivers.
I want to do the consent till the June 28th.
Do you, Mr. Mr. Cox?
Yes.
All right, so he's going to prepare a proposed consent judgment that's going to call for you to pay, the two of you to pay collectively $3,626.43. And he's going to give you a writ date of June the 28th. And that means you either have to pay up or vacate on or before the 28th. If you don't do either one of those things, you're going to be evicted. Do you understand that, Mr. Rivers?
Yes.
Mr. Cox?
Yes, sir.
Wish to enter into that agreement, Mr. Rivers?
Can you repeat that? I'm sorry.
Do you wish to enter into that agreement as I just outlined?
Yes.
Mr. Cox?
Yes, sir.
And does Mr. Visconti have your permission to sign your name to that proposed consent judgment, which he will submit to me for signature sometime today or tomorrow at the latest? Mr. Rivers?
Yes.
Mr. Cox?
Yes, sir.
Now, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that, Mr. Rivers?
Yes, sir.
Mr. Cox?
Yes, sir.
All right. Gentlemen, any questions at all? Mr. Rivers?
No.
Mr. Cox?
No, sir.
Okay, gentlemen, thank you very much. He'll submit the judgment, sign your name to it, and I'll sign the judgment. I wish you both well. Good luck to you.
Thank you.
Marian Manor versus Pearl Perry. Pearl Perry, 2502104. Is Pearl Perry here?
Robert Visconti for the plaintiff, Your Honor.
Ms. Perry, you have to start your video and unmute, please, ma'am.
Hello, I'm here.
You have to start your video.
Oh, oops. Okay. All right, I'm here. I'm sorry.
Yeah, good. Your name?
Pearl Perry.
Ma'am, did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
Yes.
All right. Adjourn 2 weeks, Jennifer.
The 23rd, Your Honor,
At?
8:30.
I'm going to adjourn this to June 23rd at 8:30. You have to provide us with proof that you've submitted an application for funding within 5 days. So you have to bring it up to the court, okay?
Okay.
You have to bring it up here and just provide proof of that. In the meantime, I'm adjourning it to June the 23rd at 8:30, okay, ma'am?
Okay, so bring it up and just take it to like the clerk or something like that?
Yes, the civil clerk.
Okay, I can do that.
Okay, any questions, ma'am?
No, that's it. Thank you so much.
Have a good day. Thank you. Marian Manor versus Jayla Bullard. 2502105. Good morning, Ms. Bullard. Your name?
Jayla Bullard.
Mr. Visconti?
Robert Visconti for the plaintiff, Your Honor.
Ma'am, did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Mr. Visconti, what is the balance?
Your Honor, the balance through June is $1,412.46.
Ma'am, can you pay that amount?
Yes.
When?
If I can get 2 weeks, I can do that. Get paid again on Friday.
So today's the 9th. Are you saying you can pay by the 23rd?
Yes.
Are you sure?
Yes.
Mr. Visconti, do you wish to enter into a proposed consent judgment with her?
Absolutely, Your Honor.
So, ma'am, he's going to give you those 4 extra days. We'd make the writ date June the 23rd. Do you agree that you owe $1412.46?
Yes.
You understand you have to pay that amount on or before the 23rd. If you don't, you have to vacate. If you don't, you're going to be evicted. Do you understand that?
Yes.
Now, does Mr. Visconti have your permission to sign your name to a proposed consent judgment that calls for you to pay $1412.46 with a writ date of June the 23rd of 25?
Yes.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes.
Do you have any questions for me at all, ma'am?
No, sir.
Okay, and he has your permission to sign your name, correct?
Yeah. Yes.
So send it over. Just make sure you pay by that day, $1412.46 by the 23rd. I wish you well. Good luck to you.
Thank you.
I'm going to put in Marian Manor. Let's put LaJacquil, Peterson. Raven Morton's not here, but you could put them in a room with Mr. Visconti.
Yes,
Thanks,
I'll
Judge.
move them right now.
And then I think Heritage Square, you're going in with Jasmine Ethridge too, right?
Right. And then I'll be ready on the Tanglewood cases after.
Perfect. Thank you.
Judge.
Thanks. Janet and Greeley Duncan versus Jeffrey Lee Duncan, 2501958. All right, Mr. and Mrs. Duncan, good morning to you.
Good morning.
Good morning.
Your names?
Janet Duncan.
Greeley Duncan.
All right, is Jeffrey Duncan here?
No,
I've not had him check in on Zoom, Your Honor.
All right, so defendant did not appear the first time. They hadn't paid for a second mailing, so we went ahead and rescheduled it. This is a complaint to recover possession of the property. Folks, has he vacated yet?
Yes, he has.
Did he turn over the keys?
Yes, he did.
So there's no reason for you to proceed any further, is there?
Right.
No.
So do you want to move to dismiss the case?
Yes.
Yes.
Jennifer, please make sure you prepare a dismissal order on this, will you?
Yes, Your Honor, I'll type one right now.
So I thank you. I'm going to go ahead and dismiss the case then, and I wish you both well. Sorry to keep you waiting so long today. Good luck to you both.
Thank you,
Thank you
Judge.
so much.
Thank you. Tracy Mitchell versus Livingston Portia Ford, 2502106. Stepped out?
I think she just left, yeah.
Where'd she go? Do you know?
I don't know. She might have went to bed.
Ma'am, just have a seat and I'll be with you momentarily, okay?
Okay.
Tanglewood versus Marshall Shearer, 2502142. Ms. Kingsley again, good morning, your appearance again.
Good morning again, Your Honor. Brianna Kingsley for the plaintiff.
Is Marshall Shearer here?
I have not had him check in, Your Honor.
You paid for a second mailing, right? Yes, you did. You can go ahead and take a default.
Thank you, Your Honor. In light of the defendant's failure to appear, I would request entry of a default possession-only judgment. Rent to retain $1,215.52. Late fees $100. That's $50 for 2 months. Court costs $189.79, and that is for a total of $1505.31 with a writ to issue after June 19th.
Defendant failed to appear. A second mailing was paid for. Defendant's entitled to a default judgment. The writ date in this case will be June the 19th. The amount to be paid to save it from the issuance of the writ is $1,505.31. What other ones do you have? Brunswick versus Gregory Goss, 2502168. Is Gregory Goss here? Yes. Your name, sir?
Gregory Goss.
Ms. Kingsley?
Plaintiff.
Did you listen to and understand the rights on the video, sir?
Yes, sir.
Do you wish to speak to a lawyer?
No, sir.
You waive your right to a lawyer?
Yes, sir.
You intend to apply for funding?
No, sir.
Ms. Kingsley, do you want to tell me what the balance is?
Yes, Your Honor. Balance due with costs $1,776.54.
Do you agree that you owe that amount, Mr. Goss?
Yes, sir.
Can you pay that, sir?
Yes, sir.
When can you pay it?
The 23rd.
So, sir, if you want to, you can enter into you want to do a consent judgment, Ms. Kingsley?
Yeah, I'm fine with that. For the 23rd?
Yes.
Yeah, so she's willing to do a consent judgment where a judgment will enter in the favor of the plaintiff and against you in that amount of $1,776.54 or 51, I'm not sure. And then she's going to give you a writ date of June the 23rd. So you'd have to pay it all by the 23rd. If you don't, you have to vacate. If you don't, you will be evicted. Do you understand that?
Yes, sir.
All right. Do you agree to those terms?
Yes, sir.
Does Ms. Kingsley have your permission to sign your name to a proposed consent judgment?
Yes, sir.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment and 10 days to appeal. Do you understand that?
Yes, sir.
All right. Ms. Kingsley, can you quickly give me a breakdown, please?
Yes. Rent to retain $1,498. Late fees of $100. That's $50 for 2 months. Costs $178.54, and that's for a total of $1,776.54.
Sir, do you understand everything here?
Yes, sir.
Do you have any questions at all?
No, sir.
All right. She's going to sign your name, send it over, and you'll just make sure you make that payment by the 23rd, 2 weeks from today, okay?
Yes, sir.
Best of luck to you. Thank you.
Thank you.
Brunswick versus Hannah Radcliffe. Hannah Radcliffe, 2502169. Is Hannah Radcliffe here? Yes, she is. Your name, ma'am?
Hannah Radcliffe.
All right. Ma'am, did you listen to and understand the rights?
I did.
You wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Brianna Kingsley for the plaintiff, Your Honor.
All right. Why don't you tell me what is the total amount owed?
Total due $1,683.20.
Do you agree that you owe that amount, ma'am?
Yes, sir.
Do you understand that you have, can you pay that, by the way?
I can pay it by the 26th.
Ms. Kingsley,
I'm fine with that.
you want to give me a breakdown here?
Yeah. Rent to retain $1,404.66. Late fees $100. That's $50 for 2 months. Court costs $178.54. Total $1,683.20.
So, ma'am, again, you agree that you owe that amount?
Yes, sir.
She's willing to give you until June 26th in a consent judgment. So a judgment would enter in favor of the plaintiff and against yourself, indicating that the amount that you owe is $1,683.20, and you'd have a writ date of June 26th, meaning you have to pay on her before that date. If you don't, you have to vacate. Do you understand that?
Yes, sir.
If you don't vacate on her before that date and don't pay, you're going to be evicted. Do you understand that?
Yes, sir.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment and 10 days to appeal. Do you understand that?
Yes, sir.
Does Ms. Kingsley have your permission to sign your name to that proposed consent judgment outlining those terms?
Yes, sir.
Do you have any questions for me at all?
No.
Okay, so judgment will enter. Writ date June 26, 1683.20 is the amount to be paid to save it. And you should get that. She'll send it over today and I'll sign it. And you should be able to get it in the next couple days. Just make sure you pay on her before that date, okay?
Thank you.
Thank you. Ms. Kingsley, do you have any more?
I do. I have one more. Hidden Gardens versus Wesley Sprinkle.
Yeah, his Wesley Sprinkle here. Come on up here, sir. Hidden Gardens versus Wesley Sprinkle, 2501951. Your name, sir?
Wesley Sprinkle.
Did you listen to and understand? Oh, this is the second hearing. We adjourned this. Can you tell me the balance that's owed?
Brianna Kingsley for the plaintiff. Judge, so this is actually an action to terminate the tenancy. We were here last a week or so ago, and Mr. Sprinkle had appeared and he requested to speak to legal aid. So I'm not sure if they're representing him.
Did you talk to somebody?
I talked to somebody.
Are they going to represent you?
They didn't say they were gonna come into court. She said I wouldn't be in court, so.
She said she wouldn't be in court?
Yeah.
Okay. So they're asking for a writ date of the 19th. Is there a reason you can't be out by the 19th?
So I'm disabled. I've lived there for 8 years and I've never had no problem with any other of the people that own that place. And now, ever since this new company took over, I'm a sex offender. And
Ella Valley, the Suzanne.
I think that they're going
Wait a second.
Yes.
You did? Okay.
Yeah.
Wait a minute.
Okay.
Jennifer, who's talking out there?
I got it.
What's the basis for this just cause termination? Wait a minute. I'm asking her.
I'm pulling up a copy of it right now, Judge. So it was originally issued, a 30-day notice was originally issued. For violations of the lease and or the rules or regulations, where the resident has engaged in verbally abusive behavior towards management. He has been violated several times for speeding through the community, causing safety issues for other residents, intentionally leaving the scene of a property damage accident. We have multiple police reports. In addition, most recently, another police report was filed on June. Looks like the incident occurred on June 1st. The police responded to his household again.
All right,
so
let's do this. Let's do this. I'm going to put you in the breakout room with Mr. Sprinkle. See if you can come up with something, okay? If you can't and you don't think you've done those things, I'm simply going to set it for trial. But you can't speed through. You can't leave scenes of property damage accidents. You can't violate. Wait, please. I'm not saying you did anything. You might have been the most model resident that they've had in the history of man. I'm just telling you, you can talk to her and they're not doing, this is a just cause termination. So you're gonna have the right to a trial, okay? But see what you might be able to work out with her.
Okay.
If there is a conditional dismissal or a judgment, I just wanna make sure that there's no language in there where he is evicted without a hearing if there's some allegation that he violated a rule and regulation of the plaintiffs. So I'll let you two talk, see what you can work out. If you can't, I'll set it for trial. Okay? All right, so you go back, he's gonna take you back in or show you where, or tell you where to go, and that's it, and I wish you well. And either way, you're coming back in front of me, okay?
Thank you very much, sir.
You don't have to thank me. Tanglewood versus Angel Justice.
Thank you.
2502107. Angel Justice here.
Robert Visconti, P61756 for the plaintiff.
This is scheduled for 9. I don't see him out there, is he, Jennifer? Or Angel might be maybe it's a female. I don't know. Probably a female. I don't know. But is Angel Justice out there? Doesn't appear so. You can go ahead and give me your figures.
Thank you, Judge. We have a rent to retain of $510. That's $440 in rent and a $70 late fee. $176.54 in costs for a grand total of $686.54. We'd ask for a judgment for possession with a writ to issue after the 19th, please.
All right, defendant failed to appear. The relief request will be granted. For the record, there was a second mailing, and defendant's in default. $686.54 is the amount to be paid to save it from the issuance of the writ, and the writ date will be on June the 19th. June the 19th. Pat Tanglewood versus Brittany Austin White. I thought I saw her name out there. Maybe I'm wrong. 2502138. Is Ms.
Yes.
There you are. Good morning. Your name?
Good morning. Brittany Austin White.
Ma'am, did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
Yes.
Do you intend to apply for funding?
No.
Okay.
No.
Here's what I'm doing. I'm going to adjourn this 1 week. Jennifer, give me a week. Give me a week down the road.
Yes. Thank you. Yes.
Slow down, Ms. Austin. Stay right where you are, please. Just stay right there, please. Stay.
Okay.
You're saying okay, but you're still walking around. Jennifer, do you have a date for me? I'm going to... Do I have landlord tenant next Monday?
Yeah.
June 16th at 8:30. You wait right there. You can talk to Lakeshore and just wait right there. Don't go anywhere. Tell Jennifer she needs to, or email her. She needs to.
Okay.
Jen, I'm setting this for next Monday. She wants to speak to a lawyer. Why am I hearing all this feedback from everybody? I don't know what's going on here. Who's talking?
Judge, which case was that again?
This is Brittany Austin White, and I'm setting it for next Monday at 8:30 in the morning, the 16th. You good that day, Mr. Visconti?
Yes, Your Honor. Thank you.
So, ma'am, we're going to set that for June the 16th at 8:30, and she wants to speak to a lawyer. So I'm going to ask you to set her up with Lakeshore, and then, ma'am, they'll take some information, and you have to follow up by calling them, and I would call them today or tomorrow, okay? Do you understand what I'm saying, Ms. Austin White? You have to unmute. You have to unmute, Ms. Austin White. You have to unmute.
Yes.
All right. Are you at work or something?
Yes, I'm at work.
Okay, so I need to be able to conduct these proceedings when you're not walking around. So just make sure next week you're in a safe haven where I can't hear anybody else, and we'll go from there. So just wait. They're going to set you up with somebody from Lakeshore, and then you have to follow up by calling the lawyer, okay?
Okay.
Antonio Henderson, Tanglewood versus Antonio Henderson, 2502141.
Robert Visconti for the plaintiff.
Morning, Mr. Henderson. Your name?
Antonio Henderson, Your Honor.
Did you listen to and understand the rights, sir?
Yes, Your Honor.
Do you wish to speak to a lawyer?
No, Your Honor.
Do you intend to apply for funding?
No, Your Honor.
Counsel, tell me how much is owed.
The total, Your Honor, through the month of June is $1,349.66.
Do you agree that you owe that amount?
Yes, Your Honor.
Can you pay that, sir?
I can pay it on the 27th.
That's fine, Your Honor.
So, sir, what he's been doing is entering into consent judgments with people. So if you agree to that, he's going to give you until June 27th, but a judgment would be prepared. He would send it to me for signature, and I would sign it, provided he has your permission to sign your name to that judgment. Does he?
Yes, Your Honor.
So you agree that you owe $1349.66, true?
Yes, Your Honor.
And you said the date is what again? June 28th?
June 27th, Your Honor, the 28th is Saturday.
June 27th. So you understand if you're giving him permission to sign your name here, and you told me you are, that you have to pay up or vacate by the 27th. If you don't do either one of those, you're going to be evicted. Do you understand that?
Yes, Your Honor.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes, Your Honor.
Fully understand everything?
Yes, Your Honor.
Any questions?
No, Your Honor.
Okay, so he'll sign your name to it, and I'll probably sign it today, tomorrow latest. Just make sure you pay by then. I wish you well. Good luck.
Thank you.
Tanglewood versus Sean Cronenwet, 2502139.
Robert Visconti for the plaintiff.
Is Sean Cronenwet here? Could you see him, Jennifer?
Yeah, I'm here.
Oh, tell me your name.
My name is John Cronenwet.
Did you listen to and understand the rights?
Yes, Your Honor.
Do you wish to speak to a lawyer?
No, Your Honor.
Do you intend to apply for funding?
No, Your Honor.
Mr.
Biscotti, your name and how much is owed?
Robert Visconti for the plaintiff, Your Honor, and we have a balance through June of $2,569.03 on this account.
Can you pay that amount, sir?
How much is it? I'm sorry, I didn't hear it.
$2569.03.
Can I have 30 days?
No. I'd be happy to talk to him in a breakout room, Your Honor.
All right, they'll put you in a breakout room to speak to him, but that's the best I can do. And then this is your last one, right?
That's my last one for Tanglewood. I have consent judgments on the Heritage Square and Marian Manor cases where I went into breakout room.
All right. I'll do all of those when you come out, okay?
Perfect. Thanks, Judge.
Thank you. Tracy Mitchell versus Livingston Porsche Ford, 2502106. Come on up, folks.
Sorry, Jen said you didn't call this one yet. It's right. It was out there.
I don't have the file.
Yeah, you should have. It should be in there. It's right here. It's this one right here.
Oh. Just said attorney. I didn't know. Okay, I'm going to take Exotic House momentarily here in Eubank, so I think I missed that one. Your name?
Tracy Mitchell.
Your name?
Portia Bullard.
Did you listen to and understand the rights on the video?
Yes.
Do you wish to speak to a lawyer?
Yes.
This is for termination of tenancy. Tell me, so were you just renting this out to her?
Yes.
And you just want her out?
Yes, I want her out and I want late fee and pass and this.
I can't hear you.
I want her out for and late fee and pat in this month's rent.
Well, you can't, hang on. You didn't fill out your money damage complaint and all this complaint.
They told me to put it on the bottom or something like that.
You just checked the box. You didn't tell us what is owed.
I wrote it on the, I don't know why it's not on there. But I wrote it on the bottom. They told me to put them out, put on a separate piece of paper. and attached it.
Jennifer, do you see a separate piece of paper on this?
Judge, let me take a look and see if something separate was scanned. It should have been in with the complaint page, but.
If you accept rent now, I just want you to know, she gets to stay in the property. If you're terminating the tenancy, you cannot accept a rental payment. You could after. I'm gonna double check on the judgment amount. How much do you think she owes you? Just tell me the total amount.
For the late fee,
Just everything.
total for the late fees, the total of at least 21.
I can't hear you.
2100.
21 what? How much are
That
the?
is what she did file a piece of paper indicating, Judge.
Oh, I need that in this file.
I'll
Is that
print it right now.
rent or just late fees?
That was just including the rent. That was late fees including the rent.
How much do you charge for late fees?
$20.
$20 what? A month?
$20 a day.
Well, you can't do that, man.
Okay.
You're charging $600 a month in late fees? If I don't pay my rent June 1 and I don't pay it at all, you tell me you're gonna charge me $600 in late fees, 20 a day? You can't do that.
That's not a problem.
I just raised mine to 70 a month maximum,
Okay.
okay? So you better refigure that. I'm gonna give you a week to go talk to a lawyer. We're gonna set you up where you can talk to Lakeshore. They're gonna take your information today, and then you have to call the Lakeshore and speak with them before next week. I'm adjourning this to June the 16th. I'm not saying there isn't a defense, but right now on its face, it does not appear that there's one.
Well,
And if
yeah, I do have a defense.
Okay,
Well, for one, I would like to go for a conditional dismissal or,
that's fine,
okay,
but you need to talk to your lawyer, and then you two need to agree on that. Okay? So I'm gonna let you talk to a lawyer. You're coming back next week at 8:30, June the 16th. You'll go down the hall, get your notice.
okay.
And
So
you,
it's good, so me just wanting her to move and vacate, it's fine.
But the lease is not even up.
slow down.
Judge.
It's not?
No, if you look on the thing, that's what I'm saying, that's why I'm asking for that, because the lease, my lease is not up until.
You can't just terminate a lease during the lease. Wait a minute, wait. You can't just terminate a lease ma'am, let me finish. You guys do what you want. You both need lawyers, if you want my honest opinion. I don't know why so many non-lawyers come in here. They don't know what they're doing, but you have that right. But if you're trying to terminate a lease because she owes you money, that's not the way it works. Is there a lease in effect still?
Yes. It's a lease still in
To
effect.
June 15th.
It's a lease in effect until June 15th. Without the property, there's damage to the property. So, which I stated that if it's damage to the property to inform me and let me know.
I'm not gonna get into all this now, ladies. I'm gonna adjourn it 1 week. You probably need a lawyer.
Can I ask you something, Judge?
You need to talk to the lawyer though first, ma'am. You said you want to talk to the lawyer.
This is just about her coming into the property, because she's been coming into the property. Can you tell me what I can do?
You're not going into the property, are you?
Yes, she's been in there twice that I know of. I have text messages.
Slow
and
down.
everything.
Does this lease say you can go into the property whenever you want?
No, I went to.
You can't do
I
that.
went to the police.
You need to talk to a lawyer before you get yourself into trouble. I'm not going to advise people on what they can and can't do,
Okay.
okay? But you can get yourself in trouble. You go talk to the lawyer, they're going to set you up on a call. You come back, I'd suggest you talk to a lawyer. I don't want to go any deeper into this, but you can't evict somebody until after the expiration of the lease. And right now, you're asking me to evict somebody on a complaint to recover possession of the property or termination of tenancy before the lease is over.
And I didn't even went there.
Listen, I didn't read the lease, ma'am. I'm not going to read your lease.
Okay.
You can argue whatever you want next week. I will pay attention. I will listen. But you have to provide me with grounds to evict. You might have been better off suing for non-payment of rent. But in this courthouse, at least in this courtroom,
That's what I thought I was doing for 9 p.m.
You didn't do it right.
But April 16th, my rent.
Slow
wasn't due
down.
or later
Slow down,
anyway.
ladies. Please slow down. I feel like a batter who's getting one thrown high and hard inside. Just let me back up. Let's slow down.
Okay.
I haven't read the lease. I don't know what the lease says. I don't want to know what the lease says. I don't know what kind of damages you're talking about, but you're also talking about going in there. She's mentioned you're going in. You can't really go in unless you've got provisions in the lease or permission, and you better be careful. That's all I'm telling you. I'm telling you both that. June 16th, 8:30. I'll see you both here next week. Thank you very much.
Thank you.
All right. I apologize to counsel for Mr. Sagatti. Exile.
Everybody?
We played that on Friday, Judge.
Which one is still a trial? I thought we had another murder case on this now.
No,
Or Lonnie Wallace is a
trial.
Langston on Jeremiah Flores.
That's a plea. I sent it to you. I signed that one up last night and filmed.
All right. Who has pleas on these on the trial docket?
I got two on the trial docket. I got Jeremiah Frera. I sent that last night.
What about Anthony Robinson?
I sent that last night too. Both of those I sent.
Any other dispositions?
I know I sent them on trial docket. They didn't make some fingerprinted thumbs. They have their fingerprint.
Okay.
But I sent those.
Where's John West? Anybody seen John West?
John Lewis Franklin. Mr. West filed a motion to withdraw because he had a conflict. He was representing two people in the same offense, and he has to get off both of them because one may testify against the other one.
Yes,
sir. And we had this discussion. He said he filed it a little while back. I don't know when, but he never did present it to the court. So we need to get it taken care of. So we did try it.
Armani Wallace.
Yes, Judge.
Y'all ready? Let's go on that one then. Let's stay ready.
Judge, we're ready, but we I found some videos late last week that were online, and I provided them to counsel. But we also are close to a resolution because of what we got, and we want to talk to the defendant. So
what do you want to do?
Just one reset, and
all right.
To the next one.
Bishop. Bishop Dustin Galmore. Okay. Ms. Stop, are we ready on that to go? Why does it say stop on?
Because it was hers, so I took it over for a certain reason, but I think that's going to be a plea according to Mr. Galmore, if I remember correctly. It should be please one, please.
Donald Barnes.
Just Mr. Lewis and I are working on a resolution. If not, I'm ready.
What does that mean? Working on? I know working. I'm sure.
The offer that he's told me should be accepted.
Where is he? Is he
I haven't heard from him, Judge.
For all these people in custody. No, Donald Barnes is not. Donald Barnes. Tommy, I asked you to call into the hall for Donald Barnes, please.
I think I saw his people house.
Donald Barnes.
So.
Have y'all seen Marvin Lewis at all today yet?
No, sir.
Okay, yeah, let's wait on him to get here, okay? Just let him go back outside. Let me know when he gets here because he should have been here 10 minutes ago and he's kind of holding up the train. Ricky Herring is now next call. You can't make this stuff up. Can't really do much without.
Mr. Kimler called in. I think he said he was ready on all his cases. And, we're tracking down one witness, but I should be ready once we tracked him down before. He just doesn't live in a permanent home. So I'll be ready this afternoon. Thanks.
On Herring, yes. And I've got Jasmine Hall.
State is ready, Your Honor. Here, good.
Okay, how long do you think that would take?
Not very long. I would imagine 1 day.
Okay. Is the defendant eligible for probation?
No.
Okay. Let's see. Do you know where your attorney is? He should be here helping you.
Yeah, I talked to him Friday.
He'd get in here whenever he ambles in on his own time
Judge,
frame.
Mr. Kimber did contact me and said
Yeah.
he'll be in another court this morning.
Which one? What's more important than somebody who could go to prison?
I
I don't know.
remember which one.
I don't know.
He did say he would be here this afternoon.
It's always-
Be on both of his cases.
Yeah, it always surprises me that some things are more important than what goes on here, but most of the stuff in here is quite important to the people involved. Oh, let's see. Yeah. Back. Let me ask the state on this, on Paul. Turn the phones off, please. My goodness. We can't make a sign bigger than don't bring the phone in. I know everybody's got one, but when it goes off, we pick them up and it's ours because you're not following the rules. Thank you. On that, the way this is where the indictment includes 6 prior thefts.
Yes, Your Honor.
3 of them. 2 of them are county court of law thefts.
Yes, Your Honor.
Then those 2 priors, I guess, would just those 2 make it a
State jail. Yes, Your Honor.
state jail felony. Then 2015 is also a county. Well, I guess that's count.
He has 3
But
prior
that's a
state jail
misdemeanor.
felonies.
So 3 prior misdemeanors. Then you've got the 180th, 263rd, and then this criminal district court.
Yes,
Those last 3 bump that state jail felony to a 3rd degree felony.
No, Your Honor, because I believe that they were reduced.
They were what?
Reduced. They were in that court, but I don't believe that they were actual. She ended up pleading to a felony.
I mean, the last 3.
The last 3 were in a district court. I think were pled down to misdemeanor thefts. So they do not count for enhancement purposes to a 3rd degree felony.
Okay, so like in the criminal district court, in this cause number, convicted of offense theft. So it was in this court and then it gets disposed of as a lesser included
Yes, sir.
misdemeanor, you think?
Yes, Your
what
Honor.
happened?
Yes.
Okay. Brandon Miller.
Your Honor, I talked to Marcus about that case. He has been sick this past week.
and was not able to come look at all of the discovery in our office. And I told him that I was not opposed to resetting that case.
Seemed to be doing okay Saturday when I saw him. I had the function. Just what I saw.
Can only tell you what-
I had a nice chat with him out there and he seemed to be doing fine. Enjoying himself. Okay, Alicia Jones, Mr. Gans. On Ms. Staub, on Alicia Jones, y'all ready on that?
Yes, sir.
Okay.
All right, I'm gonna go. Mr. Gilmore did grab a tablet because he asked me what's mine, so I don't know if he's still on set one.
He's got
I don't know.
at least 2 cases.
Okay, well, he's doing something on something.
Dylan Garner.
Ready, Your Honor.
You ready on that, Mestis?
I'm not ready, and I don't think he's here.
I don't know.
He was
Wait, is he a bond?
No, he was revoked and sent to TDC. We had a hold on him. TDC released him, and he is in the wind. So if he shows up, he needs to go back to jail.
They released him, so he's on bond.
No, he's not on bond. We have a warrant for him.
I thought he was on bond.
Yes.
Oh.
He's out.
TDC released him against our hold, and now he's in the wind, and he has no bond.
Okay, so there's a warrant.
Well, technically, I mean, technically, he's in jail. What's the procedural basis for?
What he means is there's no warrant out for him because the warrant was served and he was put in.
Yeah, I don't know. I talked to.
Released. What he's saying.
I pointed this out to Ellie, and I think Ellie's kind of been working on getting everything sorted.
Another warrant needs to be issued.
Right. I think that's what ultimately. I think that's what has happened already. But I think Ellie figured it out what we needed to do as far as getting the jail on the same page. Yeah, I think he's just hanging out with his girlfriend in Port Arthur.
It's no warrant, so we need to issue a warrant. Is that one? That one?
I guess
one needs to be issued. He's not here.
Well, they've
I thought he was going to be here.
probation.
Ask the bailiff to call into the hall for is it Dillian or Dylan?
Dylan.
Dylan Garner.
Judge Marian's here.
Dylan Garner.
Yeah.
No,
No.
there is no answer in the courtroom. I asked the bailiff to call into the hall for Dylan Garner. Are you Dylan Garner? Well, you got to speak. Come on. Don't just use hand signal. You speak English, right? I think this is him.
Yeah.
Are you Dylan Garner? Really? Okay, you're kind of shy about it. Do you recognize your client?
Yeah. That's what I said. I thought he was here.
Okay. Okay, you heard us all talking about you. You needed to
But
get our attention. I mean, we were about to send another warrant out. Well, that would have been a waste with you sitting 25 feet away.
We're ready.
You ready?
I didn't even know he was here.
Okay.
also is just out without a bond. So
Yeah, I mean, we got to fix this bond thing first. I mean, before we do anything.
Yeah, have a seat right over in there. Sorry. Have a seat right over in the jury box. Thank you.
I'll touch a second.
How does something like that happen? Dylan Smith? Is Dylan Smith here? That's you? Okay. Troy, just have a seat. Thank you. Troy Howard. Mr. Wilkerson again.
I'll hang around.
Ms. Dobb, are you ready on these?
That's gonna be the same issue that we had with Brandon Miller, Your Honor.
Johnny Davis Jr. Mr. Lamb.
Ready, assistant.
Yeah, that's yours, Mr. Lamb.
What's mine? Johnny Davis.
Davis Jr.
You guys know that.
We're way down the docket now.
Is it? Yeah, but
I don't even remember which one this is because I've been looking at something else for money.
Yeah.
Oh, yeah. No, we're dismissing it.
Okay, that's what I thought.
what are you gonna do?
I think it's gonna be dismissed.
This is going to be disposed of without a trial?
Yeah.
Okay, get it.
I did look at it again this week.
All right.
Yeah.
All right. Let's talk about this one with about 5 different lawyers on this thing. Henry Green.
I want
Langston has all of those cases except for one. Or
to do anything. Ready? I was doing last.
17 cases.
He is. Oh, he's incorrigible. I mean, Mr. Sonny gave a great deal to move all of them. I don't know what's going on. He's kind of belligerent and combative, and he's been in here before. I moved few of the cases off the trial that. Hey, this one was different.
The one with 17 would be real interesting to do, though.
Yeah, he's a worker. But I mean, you talk to him, you'll see.
Hey, do you want to have the files over there?
oh, sorry, yes, they were a big stack.
I think most of these are one case.
One case dismiss everything. He's, so.
I don't know. But we show that.
I see probably the issues. So like the jail assaults can be enhanced because the sex offender case might enhance them, but the sex offender case is jurisdictional, it's on Ohio. On the sex offenses, I found.
Yeah. That's been fixed, so we have to do.
You want to try and talk to him again this morning?
Hey, I do not have a problem doing that.
I mean, it's just one. Like I both agree. We should be able to move it. He was incompetent, then he's competent, but he's still
belligerent.
Yes. 100% plus 100%.
Yes.
Let me know.
I'll go back and give another.
I've essentially made an offer on one single case to dispose of everything.
Yes, and I was with him last night.
And did he comprehend how that would? How did he comprehend what you were talking to him about?
When we get a chance, I want you to look the teeth.
Yeah,
you form your own opinion.
I'll take him home and watch him and see how things are over the weekend. Yeah, so
I think you only need a few minutes to get a better assessment. If I remember how he has behaved in the court in the past. So if we have to, I'm already on the sex offender case for him.
But I'll give it another go to this morning.
But it's just one that should plead.
Give it the old Boy Scout try. Okay. Marvin, on yours, what are you going to do on Donald Bonds? It's going to be trial?
It's probably going to be.
Okay. Oh, thanks. What are we looking at on that punishment range? What's
It's 15 alive, I believe.
Okay, 15. Who's just got Donald Barnes?
Oh, it's an easy case for.
Not in this room anymore.
He gave
It's
me.
a Twilight Zone episode in this room. What? Do I?
I said we had a new offer the last setting. The judge
I have reference, Judge. I mean, I have four witnesses. It's going to be relatively quick.
It's not.
I am confirming because I was up until 5 minutes ago, I thought we had a plea. So I am confirming my witnesses. Okay.
Hey, John, I need to run yours up the flagpole here. You got Lewis Franklin.
No, that one I filed a motion to withdraw. A while back, we talked about.
Dylan Garner. And
I think you're dismissed.
Johnny Davis is going to be dismissed.
Yeah, so I'm ready on Carter, and the other one I'm not ready on because I needed to comment because I filed a motion to withdraw because I'm representing co-defendant and him both. So that's was going to be somebody else needs to be appointed.
Step out of here.
What's the deal on Franklin again?
I represented both of him and his co-defendant, and I filed motions to get off both of them. You let me off one of them, but not Mr. Franklin. Apparently, I'm still on that. I'm not sure why I'm still on that one as well.
Yeah, well, I got when you guys leave, I'm sure they want. Why were you on both of them?
I don't know why they put me in both of them, but just I think it's felt.
So what is it that conflicts your ability? If one of them is, if you're still with one of them,
because they're both pointing at each other, and I got information regarding both sides. So I think I'm conflicted out now because I know about both of them. Mr.
Okay, so
this is the co-defendant
on Franklin. You need to be released on that.
Yeah,
because of the co-defendant that you handle.
Right.
All right. Is he indigent or did he retain you?
Oh, indigent. I'm not. It's from a public defender. It's not private.
The next public defender on the trial list will be appointed on Lewis.
Thank you.
Franklin, please. Those two cases need to go out of here. There we go. Jeremiah Foray on Langston.
That's a plea.
Yeah, listen, bring him out, please. Foray.
That's fingerprint.
I have that one with that. Oh.
Mr. Foray, come on up. You need to meet with this lady and then come stand right there and then. Mr. Adams.
I'm ready.
Raise your right hand. You swear at one time to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
It doesn't hide them. Right, please, right there. Yep, get up one more time. Same one. What is it right there? Where's the influence on?
All right, 234150 is called the State of Texas versus. I have to read that you, Mr. Sir. And you're here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that September 3rd, 2020 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes. We did, Judge.
Yes, sir. Are you with me?
I'm with you. I just want to bring it. I'm with it.
An agreement's been reached here where you would be pleading guilty and here, I'm gonna put it in a numerical and because I can't read
We don't need to.
that you placed in that box. You would be placed in deferred or unadjudicated probation, fined $1,000, up to 10 years on probation. And there would be terms and conditions of probation, which are normal and customary. And there would be registration requirements under the sexual laws of the state of Texas that you must perform. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Sir?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
That's some stuff.
Are you pleading guilty on your own free will? Nobody forced you.
Yes.
You're pleading because you are guilty of what this alleges you did in the indictment.
No.
You didn't do this.
You did do it, right?
Yeah. Yes, sir.
What's your final answer?
Yes.
Yes. Okay. Did you just misunderstand?
Yes, sir.
Okay. I mean, you know what you've been charged with.
Yes, sir.
I'm asking you,
Oh, yes, sir.
is this true, what it alleges?
Yes, sir.
Okay, in the indictment.
Yes, sir.
All right. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it?
Oh,
Discuss
yes,
it
sir.
with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection is submitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made, correct?
Yes, sir.
You understand what you're charged with, and you discussed this with your attorney. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted.
Yeah.
Okay.
No objection.
Pre-sentence report, when?
We need to do a pre-sentence report, Your Honor.
It's a deferred.
Yes, this is a request of probation. They asked that we do a pre-sentence report on sexual assault cases.
For what purpose?
Because of the nature of the offense, Your Honor, and the complexity of it and.
What's the pre-sentence, what's the difference between, why don't we do a post-sentence report? Instead of a pre-sentence report? The quicker he gets on probation, isn't it the better idea?
Well, that's not my opinion, but it's up to you, Your Honor, what you say.
Okay, I think a post-sentence report is important because I want to know what the focus is. But I think that the general terms of probation that are normal and customary for this will be applicable. But if there are specific needs that need to be addressed, we can pick those up in a post-sentence report, okay?
Yes, Your Honor.
Okay, state okay?
Yep.
All right, that's what we'll do when we do. Do you understand the situation here?
Yes.
And you pleaded guilty voluntarily, knowingly, intelligently, and because you are guilty. All right. Anything else to add? I'm going to follow this agreement. You need a pen?
Yeah, I was right. Yeah, look. I'll take it.
If nothing further, I'm going to find you are pleading guilty today to the second-degree felony of indecency with a child voluntarily. No intelligent. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, we will come back after the post-sentence report is made so that we can review this report with all parties. And if there are any additions or changes that need to be made based upon the findings from the probation office, that will have to be included because we want to prevent or deter any further misconduct. Anything?
I just wanted to make sure we're putting him on probation today, but doing what would amount to a pre-sentence report.
Yeah, we'll call it a post-sentence because he's been sentenced today. But it would work just like a pre-sentence report if there's something that we need.
Okay. Understood. That's what's the
What's going on? So this is like the most important thing in your life, and you're looking around. What's going on?
People.
Sir?
I was just looking at my people.
This is the most important event in your life, sir.
Yes, sir.
I mean, you're looking at up to 20 years in prison.
Yes, sir.
You want to do some more public affairs, work, or you got to focus on the game here. This is the most important thing in your life, isn't it? 20 years in prison?
Yes, sir.
Okay. And also the victimization of a child. These are all serious things. You're not in a parade waving to the crowd. Yeah. Get your eye involved here. Come on. All right. Anything else, Dan?
That's it.
How long have you been in jail now?
In January 30th.
Of this year?
Yes, sir.
It's about 6 months? 5 months?
Yes, sir.
How's that working out for you? Yeah, I wouldn't be happy with it. You're not enjoying yourself.
No, sir.
Can you imagine what 20 years in prison would be like? Are you focused now?
Yes, sir.
All right. Just have a seat over there and you'll see the probation office and we'll go over terms and conditions of probation.
Thank you all. You can just, that's there.
You just
Check it out and check it out. City probation office and stuff. Look.
Anthony Robinson, please.
He's,
You go. Okay, two cases. Is he pleading to both or one?
No, he's pleading to one. They're going to dismiss the other one.
Which one?
He's pleading to the burglary and they're dismissing the kidnapping.
Okay.
And it's 6 years off of him.
Thank you. Anthony Robinson, please.
He's there.
That's you? Come on over here.
Please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
No.
Okay. You have your right hand first.
Yeah.
There. You can have one more time if you do. You don't stop.
Are you Anthony Robinson?
Yes, sir.
And you were here with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 14th, 2023 in Jefferson County, Texas, you committed the second-degree felony of burglary of a habitation. Do you understand what you were charged with here, sir?
Yes, sir.
If convicted, you okay? Hey, I had an allergy attack this weekend myself. I don't know what that was, but I woke up fine today, but
Urgent care, I'm not.
and Ellie's in there kind of sneezing.
Must be the Sahara dust.
The Sahara dust is here already.
Alright.
Is that what rode in on a camel last week? Yeah. Sahara dust.
Hey. You could
What I heard. It's this. You're facing this is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 6 years in prison. You would be given credit for all time served. And then another pending case, 23 CR1 Stand by.
0121, Judge.
Send him somewhere.
0121.
No. I don't know what.
Is it underneath?
Good work. Yeah, 23 CR 0121 would be dismissed. Is that your understanding of the agreement? Yes, sir. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty? Guilty. Are you pleading guilty voluntarily? That is on your own free will and because you are dishonest?
Yes, sir.
I'm not going to be provisional options and then see the leaders of statutes that the British signed off.
I show you what's marked as States Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney? Or the contents altered or incorrect?
Yes, sir.
States Exhibit 1 tendered into evidence.
No objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyers. All of this is true. It states so help you God.
Yes, sir.
States Exhibit 1.
No objection.
Is made a part of the record without objection. It is admitted. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement and find you are pleading guilty today, sir, voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. The States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now so find you guilty beyond a reasonable doubt of this burglary of a habitation, second degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. Do you understand what has happened today?
Yes, sir.
23 CR 121, there's a motion to dismiss this case because of this plea in 111. Any objection?
No objection.
It is done. Thank you. That is all.
That's what you just have to be 5 minutes. 5 minutes.
Here. Within the signature. Yes. Dustin Galmore, did Dustin ever show up?
Yes, sir. He's here. Something.
Hey, Mr. Wilkerson. Yeah, I'm glad you're here. They were just talking about you, little Brandon Miller. And I think there's another one, Troy Howard.
Yes.
And I'm sorry, there's Michael Mitchell. 3. What are we doing?
So Troy Howard and Brandon Miller are still trials. Michael Mitchell, I think we're gonna have that one worked out in just a few minutes if we can hold. And Judge, just for the court's information, I have a procedure scheduled Wednesday afternoon.
Okay, it's Troy Howard and
Brandon Miller.
and Brandon Miller.
And in Brandon Miller, I still need to review the evidence in the DA's office. So I plan on going after the work.
Okay,
You want to come with administrators? You want to go to or something?
yeah. I'm talking about the prosecutor. It's going to be Ms. Staub and
One Sunday, that's when probably gonna work out here.
and Ms. Staub's on both of them. The Brandon Miller,
Yes.
where are we on that for the state? Y'all are ready, I presume?
Well, as Marcus told me that he wasn't going to be ready, I am not
He
ready.
says he's not. And then Troy Howard, what about that one? We can. Yes, 2 or 6. They're all serious cases. Yeah, obviously. They're all serious here, but.
Yeah.
But this Brandon Miller, that's, I've never had one of these not get disposed of by a building, you know.
Well, it will.
When can you make a decision on that?
Probably later today. He has an appointment at my office. this
Okay,
afternoon.
okay, let us know if we can do this. Also, you've got this, you're right on prohibited substance. Yeah, you're working on that right
Yes.
now. Let me know when you're through with that. Okay, let me reset. Miller, reset. 3 weeks, okay?
Yes,
An announcement. And then Troy Howard, I'm gonna put it on the trial docket in 5 weeks.
That's fine.
that's fine.
Okay.
Would that be a preference for setting on?
Under the law, it's,
Because they're.
it is generally presumed to be, under the rules of law, it has a preferential placing.
Yes.
Because it's.
I just didn't know what other cases might be on the top.
Sexual assaults of children, those are of most importance to all of us.
Thank you.
Okay. Brandon, numbers 2, thank you. Nobody's seen Mr. Gallo.
Okay, Judge.
Yeah.
I'll bet you.
Just right in front of me. Hello. And you bit. Thank God you weren't a snake.
That's right.
You'd have bit me. It's Barrett Bishop.
Barrett Bishop's present. I'll turn in, please. We'll do it whenever the court's ready.
All right, come on up. Mr. Bishop.
Yeah, thank you.
Raise your right hand, please. I swear or affirm that the city of Hampton will not self-God. You can do right. Black or in box. Either one of them.
Oh, yeah. Oh, they were. What's our plan? There's 2 of these, pleading to 2 or 1?
2. Pleading to 2 to attempted, and there's a cap.
Are they the same type of plea?
Yes, sir.
Agreement?
Yes, sir.
You okay, okay?
No.
She's struggling, Judge.
Yeah.
Thank you.
Can't soar with the eagles if you're hooting with the owls all night.
I've never along with the owls.
Let me ask you about this.
Yes, sir.
Okay, I'm looking at the indictments which allege first-degree felonies of sexual assault of a child. We're going to vote on attempted.
Yes, sir.
Isn't that 1 degree less?
Yes,
But these are third degrees. From a first degree to a third is not 1 degree less.
the agreement was to drop the first degree enhancement. There's an enhancement in the indictment.
What
is it a first? It alleges
The child being under the age of, I think, what is it?
Younger than 17.
It's the familiar relationship.
Oh, is it? Let me say, Judge.
It alleges a familiar relationship.
I don't think.
It doesn't. Does not.
I think it's just.
Yes, but he was just like, oh, it makes sense.
Can I see the indictment, please, sir?
The
I
one?
don't have my file. Can I see your indictment? Yes, sir. There's an enhancement down here under this last paragraph here. It says has a familiar relationship or prohibited from having sex with because of that relationship. So we're abandoning that and just proceeding on the second degree and then dropping it down to a first degree. This that prohibited from having sex under 25, well, 2, I believe, or something along those lines.
Oh,
that makes it a first degree. So we're just abandoning that. We're abandoning that language, making it.
It just referred to the statute.
Yes, sir. Then we're just making it a second degree and then reducing, doing an attempted. So I'm abandoning the language of the familiar part.
Okay. Well, there's no language that says that, but it just refers to the general
Yes, sir.
section of 2502.
Yes, sir.
With and this is 429. What are we going to do with 430?
Same thing, same exactly.
Okay, in each of these cases, does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
He does, and we may, Your Honor.
In summary, in cause numbers 23 CR 429 and 430, in summary, these indictments allege that on or about June 1st, 2020, in cause number 429, and on or about August 31st, 2020, in cause number 430, in Jefferson County, Texas, it is alleged you committed the first degree felonies of sexual assault of a child. Do you understand what you're charged with in each of these cases? Agreements have been reached in each of these cases. You would be pleading guilty to the lesser included offense of attempted
sexual assault of a child. Yes, sir.
sexual assault of a child. In each case, which would be third degree felonies in the way the case is indicted under section 2502, that would be dropped.
That is abandoned, yes, sir.
Abandoned by the parties, so the lesser included offense becomes a third degree felony of attempted sexual assault of a child under these circumstances, which means in each of these cases, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached. Whatever sentence shall not exceed, is that 3?
Yes. My handwriting.
Yeah, that's sort of. Whatever sentence shall not exceed a cap of 3 years in prison. So what we have here are the options, which would run concurrently with each other. So you're looking at no less than 2, nor more than 3 years confinement in prison.
That's correct. That's
Deferred or unadjudicated probation could be assessed. Is regular probation
I don't think
an
so.
option under these circumstances?
I don't know if it's attempted, it might be.
It's involving a child less than 17.
Tensils usually are 3G as well, right?
Not necessarily.
Anyway, there's going to be a plea agreement, a pre-sentence report prepared. We will all come back, review it, make sure that it's true and accurate. Each party gets to sound in, and then the court will make its decision. Is that your understanding of what's going to happen?
Yes, sir.
If I follow this, agreement, you have no right of appeal. Do you understand?
Yes, sir.
And again, how do you plead here for this lesser included, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Yep. Voluntarily, understand it, discuss it with your attorney, or the contents true and correct. State's Exhibit 1 is tendered into evidence and without objection is submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's free and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you were totally satisfied with the representation provided by your lawyer. All of this is true. The state so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report will be prepared to come back on
July 15th.
July 15th. Everybody will sound in, and the court will make its decision. Do you understand?
Yes,
Okay. That is all. Get a reset.
I'm right there for me.
Langston Adams?
Well, I'm not free to go there. I gotta get more. Please, speak. Keep moving back to Adams.
Okay.
On that. Spartan back and so yeah, that is wow. Same thing, yeah.
Back to all of this mess. Did Langston Adams gone? Mr. Wilkerson? He's gone.
I think he's working on a plea on Mitchell.
Gotcha. Okay, here's what we're going to do. Mr. Laird, you're ready on Ricky Herring, that arson.
pretty sure we're trying to track down one witness, but I think we'll have him.
Mr. Kimler, who feels like he's not necessary to be here on trial dockets for other, we're going to have Herring 1 and Ms. Staub, you're ready on Jasmine Hall. 2, Marvin, you're ready on Donald Barnes. 3, Alicia Jones.
That's me, Judge.
You're ready on Alicia Jones?
No, I'm not ready for that.
Why not?
Judge, located or found some witnesses buried in the video.
Yeah.
Got somebody trying.
What do you want?
Just a regular resetting.
There isn't anything regular here in this room anymore.
It's like an irregular resetting.
An irregular, that's pretty good. Of House full weeks.
Sounds good.
Okay.
Thank you, Judge.
Yes, sir. Dylan Garner. John?
I'm not ready, Judge.
Okay,
We just have a bond issue on that.
we have a bond issue though. Where's Mr. Garner again? Yeah, we're going to deal with you here in a second. And John, though it's John West is your attorney, he's in the back. We got to work with him on this. And on Dylan Smith, how are y'all doing on that one, Miss Staub?
Oh, there you go.
Dylan Smith,
I'm ready.
forgery. Okay. That one
Everyone's
will
ready
be,
on all three.
that one will be 4. It's a right Kendall case. And then that finally leaves us Henry Green. I guess that's a mess that we got to figure out. And so it will be in that order again, Herring, Paul, Barnes, Smith. And then I need to see all the different lawyers on Henry Green's 15 cases. And then Mr. Wilkerson, who says this is going to be a plea on this.
He's over signing the number right now, Judge.
Here are these. Thank you. Thanks, Duncan.
She should have.
I have. They already have it.
No.
See, you already giving all the others.
No.
Okay.
Do you want half of it?
Yes.
All right, here's half of it.
Thank you. LaShonda Elam. Langston, of course. Not here. Jeremy Isaac is Langston Adams, who is of course not here. Devontae Hall, Don.
Right. Needs to be brought up.
He needs to be brought up. Please, Devontae Hall. Thank you.
Oh, well, it's in same pair, please.
It is.
Okay, never mind. I already did.
Yeah. Both of them are NPR booths.
Okay. I'm done.
No, you didn't give me enough files. Don's after this group.
Of course.
Give me a.
I'll just give you the rest of them.
By the way, Randy Arline, 25 CR 109 with David Grove, that has been dismissed for the record. And I'm sorry, reset. And David Grove's next case, Jeremy Barabin, 24 CR 1544. That case has apparently been dismissed. And you were Mr. Hall?
Yes, sir.
Okay, you were Mr. Dusler, you're currently. 16-24463 is called. The state of Texas versus Devontae Montez Hall, present with Mr. Dusler and the state's attorney. There's a first amended motion to revoke unadjudicated probation, correct?
That's correct.
That's about as old as I am. Wow. That one's been. Have you just, was he?
He's been in the federal
prison waiting?
Yes, Your Honor.
Does the defendant waive a formal reading of this first amended motion to revoke unadjudicated probation? Can we proceed in session? Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion states that on
November 28th, 2016, in this court, you were placed on 10 years deferred or unadjudicated probation for assault on a public servant. Do you understand what you're charged with here, sir?
Yes, sir. Counts 1 and 3, I think.
Huh?
I believe 1 and 3 would be sufficient.
What are we doing on this?
It's 2 years, 2 years CDC.
Number one, states you failed to report to the Jefferson County Probation Office on or since March 4th, 1st, 2017. It doesn't say an end, but it must have been for a long time. Is that true?
Yes.
Do you understand that was required of you under condition 4 of your probation order, a violation of one or more violations of probation orders? That's enough to grant the motion to revoke probation. Your probation could be revoked. You can now be found guilty and sentenced up to the full range of punishment. This was a 3rd-degree felony, so you were looking at no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. What else?
1 and 3, Your Honor.
And 3 states you provided urine sample on or about March 1st, 2017, which showed the presence of cocaine in your system, a violation of condition 10 of your probation order. Is that true as it is alleged? And are you pleading true and correct to that voluntarily?
Yes, sir.
And you understand and appreciate the consequences of pleading true as we've talked about. So
Yes.
an agreement has been reached where you will be pleading true as you have done. Your probation shall be revoked. You will be sentenced to 2 years in prison. You will be given, of course, credit for all time you've served in connection with that sentence. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of this case. Do you understand?
Yes, sir.
Show you what's marked here as State's Exhibit 1. Did you sign that document voluntarily, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection admitted. This states you understand that you are giving up all rights of appeal if I follow this agreement.
Yeah.
I'm going to do that.
Yeah. All right.
Anything else? If not, I'm going to find there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater, as you have, Mr. Hall, have pleaded true voluntarily, knowingly, intelligently to allegations 1 and 3 of this first amended motion to revoke unadjudicated probation. Thus, you're deferred or unadjudicated probation hereby revoked. Earlier in this case, you had pleaded guilty voluntarily and you were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence from State's Exhibit 1 admitted at your plea to find you guilty beyond a reasonable doubt at that time. Deferred any finding. Now, we are resurrecting that all those documents and those findings. And since your probation is hereby revoked, I hereby now find you guilty of this assault on a public servant, which was a 3rd-degree felony. And I am following this agreement. You are hereby sentenced to confinement in the institution division of the Texas Department of Criminal Justice to serve a term of 2 years. Do you understand what has happened today, sir?
Yes.
Anything else? No, sir. Okay, that is all. Thank you. Maurice Kendall.
To please,
Maurice Kendall.
Kenlaw. There's also a motion to revoke. There is no agreement on this.
Oh, it's unagreed?
Yes, sir. And I think Mr. Young is going to need to make an oral amendment to the motion.
What's going on? How are you? Maurice Kendall? That's you, sir. Come on. 21-36805 is called the State of Texas versus Maurice Kenlaw. That is you, Mr. President, with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation, which was filed on April 12 of 2024? Can we proceed in assembly?
Yes, sir, but I think the state needs to, counts 1 and 2, the motion.
That's correct, Judge.
Mr. Kenlaw, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, lower your hand. Yes, go ahead.
Yeah, counts 1 and 2,
Counts 1 and 2.
there's a reference that this offense occurred in Chambers County. In fact, it occurred in Orange County.
Anthony Robbins.
So,
So allegations 1 and 2 should reflect Orange County rather than Chambers County.
that's correct, Judge.
Any objection to that?
No, sir.
And that's what the defense understands is correct.
That is correct. And those are the counts he's going to be pleading truth to as well.
That is changed and corrected to without agreement.
This is the PC from that offense, really.
Okay. Allegation 1 here states that you committed the offense of operating a motor vehicle while intoxicated with a child under 15 years of age on or about March 10th, 2024 in Orange County, Texas, in violation of condition 1 of your probation order, which is don't commit an offense. Is that allegation true or untrue?
So,
Number 2 states you committed the offense of abandoning or endangering a child on or about March 10th, 2024 in Orange County, Texas against the peace and dignity of the state, also in violation of condition 1 of your probation order. Is that true and correct?
so
Are you pleading true and correct allegations 1 and 2 voluntarily? No, intelligently, and because those allegations are true. Do you understand that a knowing and voluntary plea of truth of 1 or more violations of probation, that is enough to grant the motion to revoke probation? Your probation can be revoked. You can now be found. Stand by. No, you were on regular probation, so your probation could be revoked and you could be sentenced to no less than 2 nor more than 5 years confinement in prison. For each. Knowing that, you insist on pleading truth.
So
I find you pleading truth voluntarily. You understand and appreciate the consequences of pleading truth. This is unagreed. Stand. You got a copy of this probable cause affidavit?
Yes,
That's in tiny, tiny, tiny print.
Sorry about that, Judge. I blame the probation officer.
Okay.
Not yet. I just a little lawsuit.
Yes, that's not your actual.
Well, intoxication has been kind of your problem, hasn't it? On a bunch of different things here. Now, you're put on probation because a child was in jeopardy. And then now we've got some other allegations here. All involving intoxication. Okay. Go ahead.
Well, he absolutely recognizes that alcoholism is a problem. And he wants to address that problem. And in fact, he has voluntarily submitted himself to substance abuse classes. He has a certificate will present to the floor showing that he has completed a substance abuse program to try to address that problem. He knows that that's a problem that's going to continue, that he's got to still deal with it the rest of his life. And he really believes if the court would continue him on probation.
Now, this was, where was this conducted and completed?
What was it, Jim?
At the state jail, when you were at the state jail.
Yes. And he actually served 15 months in state jail because of the Orange County offenses I mentioned in the motion to revoke. But what he and I have discussed, and he feels like that if the court would continue him on probation, it would force him to be monitored to where he can continue his substance abuse treatment. Hopefully lick this problem that he's had with alcohol. And by the time that probation's over with, he's going to be clean and be able to keep clean. He can do it on his own, but I think he's got a better shot of doing it when he's under supervision. And that's what he's asking the court to do, is consider keeping him on probation where you can monitor him.
Are you still on parole, Bill? Are you on parole for that state jail?
No. No, it was on parole.
Okay.
He received a full 15 months, which he served. So in essence, what he's asking for is consider that as his punishment and give him a second chance. The state is in
disagreement. I mean, is that what you're saying?
Sure.
Well, I gave you a second chance when I put you on probation, July 28th, 2022. How many chances does someone get?
Well, first of all, I didn't kill nobody.
Thank God. Yeah, I thank the creator, not you.
Yeah. I work for a living. Every time I came in front of y'all, I always had a job. I don't lie, I don't steal. I don't kill, so yeah.
But you've had a consistent pattern here now of putting children in harm's way. You know, anything wrong? Do you see anything wrong with that? That's terrible. You know, I did.
That was only one time. First time I put my probation, they didn't involve like.
How many times is too many? You got to agree. The child put in jeopardy because of your having that's.
I was put on probation. I was still in my addiction.
Probation. And it's kind of disappointing to me here because we have a 92% success rate and we're real proud of it on probation. 92%. I hate to see, I brag about it when I'm speaking at functions and we're very proud of that because the national average is 75.
Right.
And
we have a high rate of probation success, but it's because our probation officers are good. But you've got to carry your own weight like always. You got to do some of the swimming here and the rowing. And
That's why
this was kind of disappointing. Well, you were sentenced first time. What were you in the state jail for?
He was in state jail for those offenses, Judge.
For these that he just pleaded
yes,
true to?
Yes. Yes.
Okay.
If I may, Your Honor.
Was it out of this court?
No, sir. That was out of Orange County. That's why he pled true to it. He knows that he's guilty of it.
Okay.
When this man appeared before you,
How many times do you have credit, please? Go ahead.
He's got about 220 days credit, is what we know, Judge. When we appeared in front of you, Your Honor, in 2022, there was a cap agreement of 5 years, and I argued for the 5-year TDC time because of the assault on a peace officer that Your Honor made the choice, listened to his defense counsel make a really good argument that he needed some help, and we gave him an opportunity to be put on probation, despite the fact that he had 3 felony convictions before that sentence date. So now he stands here with 5 felony convictions, asking Your Honor for another opportunity. As you know, I don't agree with that. Had we sentenced him then, he wouldn't have had a new offense. Now, that's not me chastising the court. Your Honor is always really good about giving people an opportunity. Certainly saw that he could succeed. And in fact, the probation officer told me he was really doing well up until he committed this new offense. The problem is he only made about 15 months. And then he gets sent to state jail for another 15 months. If Your Honor does give him the opportunity, it's not one that I'm in agreement with.
Opportunity, what do you mean?
He's asking
back on probation?
Yeah, I just don't agree with it. I'm asking for 5 years, Judge.
Okay. Yeah, you get to say something. Go ahead.
Before this, I never took a alcohol anonymous class. I never had help by alcohol. I understand you gave me probation, but
yeah, I kind of stuck my neck out.
You know, I needed more help than that, and I got it once I went to state jail.
Okay.
I was around other people that had addictions. We was able to help one another. I never had an alcohol class, so that was my first time taking it. Really help. I'm asking this, can I continue to take it?
Sir?
All I'm asking is, can I continue to take it, continue to help?
There's nothing to stop you from continuing to do it on your own, but how many chances do you get? I mean, I'm opening the door for you. I open it for everybody else. You were put on probation already. You failed. How many? Yes. I know the answer to it. I just, you know, it's your life. No one knows better than your life. How many misdemeanors do you have, and how many felony convictions do you have?
Well, felonies probably 3 or 4, and misdemeanors 2.
Yeah, 3 and 3.
3 and 3.
No, 6. But the point being is that you don't know for sure. You've heard something about your own life.
Long time.
I know. But it's not something like that should never be in the past, because it should be in something that was important that you remember. But it had been a while. You're right. But the drinking problem is a problem. All right. Anything else to add?
No, sir. We have nothing.
If nothing,
I think he's expressed to me.
If nothing further, there is sufficient evidence supporting this motion to give both probation to grant it. That's right at the ponderance of the evidence.
Good job, Marcus.
We're working up here, folks.
Thank you. That's allegation 1 and 2, correct? They've been proven.
Yes.
As the defendant has pleaded truth, voluntarily, knowingly, intelligently to those allegations. And that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Your probation is hereby revoked, sir, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You'll be given credit for all time that you have served in connection with that. And this is yours. So I don't know if you'll be released immediately or if you're going to have to stay in a little longer, but fix all this mess, sir. Anything else? No. That is all. Thank you. I have Jacoby Fleming. David Grove, what are we going to do on that?
He's been declared to be incompetent, I believe.
Okay, we're going to do a competency hearing, right, on that? Okay. Langston, Adams? No, Marcus. Do you have something you need to do?
Yes, Judge, we've got Mitchell to ready.
Where's that from?
It's from the top.
Come on up, Mitchell. Custody, that's you, sir? Come on now.
Who needs to, don't find me anything like that.
This lady's gonna have to fingerprint you real quick. Thank you.
Oh, yeah.
No, it's my fault. Yeah.
Please say the right one. You swear or affirm to tell the truth, but you can have another do something like it. Your right number.
Okay. Oh, yeah, this goes in the phone. Thank you.
Let's see. Get up one more time? No, but actually. Okay. You don't have this. Okay.
24 CR 1682 is now called the state of Texas versus Michael Mitchell. That's you. And your attorney is Mr. Wilkerson. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
What are we doing? One?
Yes.
Just one paragraph. One.
Yes, sir.
Paragraph 1 states and alleges that on or about April 22nd, 2024 in Jefferson County, Texas, you committed the 3rd-degree felony of having a prohibited substance in a correctional facility. Do you understand what you're charged with here, sir?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached where you would be pleading guilty, sentenced to 6 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and tendered.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
That's it. Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is made.
Yes.
Sir, I'm going to follow this agreement. If nothing further, I'm going to add you are pleading guilty today voluntarily. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this indictment, charging you with this 3rd-degree felony of having a prohibited substance in a correctional facility. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. You understand what's happened today, sir?
Yes, sir.
Good luck to you, sir. Thank you.
Judge, I also have one more on the trial docket.
Go ahead.
Edros Figueroa.
Okay. plan?
I mean, I'm ready. We've been ready on that, and I believe the state is as well. My only issue with that it again is a procedure this week.
I don't think that's not on this week. That's not on this week.
It's it's showing up in my queue. Yeah. He's here. Like when I sign in to do.
Yeah.
Please.
It may have been on the docket. Because they'll only put a couple pages worth on there.
Yeah.
And it just hasn't been moved yet, but I'm not sure.
Okay.
I don't see it on the docket or the announcement. So it's just in the computer on.
Who is it? What's in?
Address.
Judge.
Does he need a reset, Lacey?
Troy Howard?
No, Troy Howard looks like a different one, Judge, and you reset it out in 5 weeks. He apparently isn't in the paper document.
Okay. So he doesn't need a reset, but it didn't make the cut for this trial.
Didn't make the cut. Good.
Yeah, I'll.
Okay. And then,
Yeah, I'm gonna email you now. Yeah, I have to work and I'm just.
We're emailing.
Thank you. You're welcome.
Doing a lot of emailing.
Yeah, creative and scheduling, Judge.
I was the same on. Yeah, I'm talking to you in some festival, finance and that, but yes. So, was all, yeah, so far. Yeah, yeah. Oh. So then yes, and then you the ground in the grass of the fire, you know, on some days. It was.
And this is Johnny Ray Davis. Y'all got a motion to dismiss in front of me, correct? Mr. Laird? On Johnny Davis?
Yes, sir.
Got a motion to dismiss. I'm signing that right now.
Thank you, Judge. Got it. On the
You know what? I think that needs to go back to me. Sorry. Yeah, the dismissal on Davis. Send it back to me. I have something here on Stephen O'Quinn. What's that? Who's got that? Stephen O'Quinn? Where is that?
Just, that's with Mr. Adams on page 2.
The fully dry.
Where's Langston?
And Kevin Thompson. Oh, Quinn and Thompson, I have, please in the queue. David Grove. Okay, let me get back to you on Jacoby Fleming. Do we need him out at all?
Good. I filed a motion in October. I don't have a copy of it being granted by the court.
A motion for what?
So I'm not sure where we are on that.
No, a motion for what?
A motion to have him examined for competency.
He's been examined. We just got this report.
That's what I thought. I just don't have one in my file.
2 weeks ago.
Yes, sir.
Okay.
I don't think we need him though, Judge.
He needs a copy of this. He's been determined to be incompetent.
Yes, sir.
It should be in your email, but I'll make it up.
So that's fine. I can get that. I'm not worried about that. I can get that later.
Does he need to come out?
I don't think so.
All right.
If he's incompetent, I believe that's what. He has 2 cases, Your Honor.
David. It's for you. On Jacoby Fleming, the court has a report from Dr. Ed Lawson, psychiatrist here in Jefferson County, Texas, who analyzed and evaluated the defendant in these 2 cause numbers, 24CR 1565 and 1892. And upon his evaluation, the defendant is deemed incompetent to proceed to a resolution of his legal issues as he is diagnosed with schizoaffective disorder and is still symptomatic. And he does not have an understanding of his legal charges, nor does he have an adequate understanding of the basic legal proceedings, and it's impossible to communicate with him with any meaningful level. And he is deemed unable with a meaningful degree of rational understanding to work with his attorney to prepare the defense. He is mentally ill. He will need more aggressive treatment on an inpatient basis if that will be ordered. And it is expected, based upon reasonable psychiatric probability, that he will regain competency with intensive medication management. All right, this will be Identified as court's exhibit 1 on this date, made a part of the record in this case, and sealed and orders in conformance with Dr. Edgar Pond's recommendations will be prepared in the case. Anything else on that? Nothing from the state. Terrell Johnson. David, it's an announcement. Terrell Johnson, and then I've got Ashley Nelson. Anything at all?
No, Your Honor, just, let me just find the notation, I believe.
Dr. Fleming has 2 packets.
No, sir, I received some information in this case, and then it was.
What do you want to do today on?
Judge, I've lost my discovery that I had. It was taken away from the portal, and I'll talk to the DA, and I'm sure I'll get it back.
You're asking for additional time?
Additional time, yes,
How
because
much?
it was, I'd say 4 weeks.
From discovery in the new portal, it's because this case is old, he had discovery in the old portal.
4 weeks. We said 4 weeks. Ashley Nelson. And 24 CR 1985 and 1986.
Judge Ashley Nelson, I will be filing a motion for competency in both cases.
Do it and get it done, okay? I'll review it in 2 weeks, because we don't want to lollygag on people who may be mentally ill, right?
Yes, sir.
Thank you. Monica Vincent.
This is a case in which I have discovered a medical record. I've ordered a copy, but I have not received them, so I'd like to ask for 4 weeks discovery.
Okay. Is she in custody and in jail?
Yes, sir. She's in custody. I spoke with her this morning. These are not necessarily competency, although that may be dealt with. They're
okay.
Mitigatory.
Okay.
Records.
Oh, I haven't moved. You've been on this case for 6 months.
Yes, sir.
That's what it shows.
Yes, sir. I didn't find out about these records and they have now been ordered, but spoke to another attorney. He previously.
Okay, I'm gonna reset for 4 weeks. What about William Weston?
William Weston is another.
That one was reset already.
Do we have any other dispositions? Any, please, Marvin, you don't have anything, right?
No, sir.
Did we take care of your case off the trial document?
Numbered him, Judge.
Your number?
Yeah.
All right. Charter Simpson. Is he in custody? Hold on, John.
It reminded me that.
Matter again, sir, your name again was? I'm sorry?
Dylan Gordon.
Mr. Gordon?
Dylan Garner. He doesn't have a bond. He was just released from TDC.
Okay. What are we gonna,
He needs to. Get a bond set and make
Who
one.
is this attorney?
John West.
Where's Jonathan? Watsky. John.
Yes, sir.
Come on, Mr. Garner.
Here, Judge.
Dylan, come on, get up, please.
Got another active. Okay. For possession.
Revoked him on the one that he had the new offense for it, or the.
All right, he's, this is 24 CR 349 manslaughter, second degree felony.
Right.
And this was indicted a year and a half ago.
Yeah, well, he was revoked, Your Honor, and sent off to TC.
When did you get released?
To April 4th. Right, 2 months.
Okay. So, I need a public safety report.
I don't have one because he was in TDC.
I guess technically you do, but you're not considering
Technically do.
You're not considering a bond issue though.
Oh, I thought he didn't have a bond.
He doesn't have anything. He has a bond amount set where he could post bond, but he's supposed to be in jail.
Oh, okay. I thought there was not a bond set. What is the bond?
100,000.
100,000? Okay.
Right. So I mean, it's just, yeah, I guess technically.
Six, seven. Mr. Sagatti. Where are you at, Mr. Sagatti? Is he out there, Jen? I don't know how I missed this one. My apology. Do I have anybody out there in this case?
He was there, Your Honor. I'm just looking to see.
All right. Visconti, are you ready on Heritage 1 versus Jasmine Ethridge?
Yes, Your Honor, I am.
Heritage 1, Swear versus Jasmine Ethridge, 2502047. Ms. Ethridge, your name?
Jasmine Ethridge.
All right, Visconti?
Robert Visconti for the plaintiff, Your Honor. We have a proposed consent judgment in this matter. Which reflects an arrearage of $880. Court costs of $176.54 for a total of $1,056.54. We've agreed to extend the writ date in this matter to 6/27, and Ms. Ethridge has given me permission to sign her name to the order.
Is that right, ma'am?
That's correct, yes.
So you agree that you owe that amount, $105,654, with the understanding you have to pay up or vacate on or before the 27th. If you don't pay up and you don't vacate, you're going to be evicted. You understand that?
Yes, sir.
Sure, I'm represented by a lawyer. You have 3 business days to come in here and fill out a motion to set aside the judgment, and you have 10 days to appeal this. Do you understand that?
I do.
Does Mr. Visconti have your permission to sign your name to this proposed consent judgment?
Yes.
You fully understand everything?
I do.
Any questions?
No.
Okay, I wish you well. 105,654 will be the amount. The writ date will be the 27th. Good luck of June. Thank you, ma'am. Good luck to you. Thank you.
Thank you.
Judge, that attorney is back in when you're done with Mr.
My
Visconti.
apologies to you, counsel. Exotic House Reynolds versus John Eubank.
Oh, no problem, Your Honor.
167. I apologize. I don't know what happened. It somehow got put on the bottom. My apologies. Is John Eubank here?
No, Your Honor, I did not have him check in.
Your appearance, Mr. Denia?
Yes, good morning, Your Honor. Michael Denha, P86036 for the plaintiff.
All right, go ahead, give me your figures. You're entitled to a default. You paid for a second mailing.
Your Honor, I believe this is just a termination of tenancy. So we just request a writ date of June 19th, 2025. And the default judgment.
Good enough. Defendant failed to appear, default judgment entered. Writ date will be June the 19th. I'm going to ask you to make sure you e-file that today, okay?
Absolutely, Your Honor. Thank you.
Sorry about this. I don't know what happened. Good luck.
Oh, no worries. Thank you.
Now, which one, counsel? Do you have Tanglewood versus Cronenwet?
I'm ready on that one as well.
Tanglewood versus Sean Cronenwet, 2502139. Your appearance, Mr. Cronenwet?
Yes, I'm here.
Nice and loud for me, sir.
Yeah, my name's Sean Cronenwet.
Counsel?
Robert Visconti for the plaintiff, Your Honor. We have a proposed consent judgment in this matter as well.
Okay.
Rent retains $2,392.49. Court costs are $176.54 for a total of $2,569.03. We have an agreement that's going to be set forth. A payment plan is going to be set forth in paragraph 10 of the order. Mr. Cronenwet's going to pay $1,000 by June 20th. He's going to pay $1,569.03 by July 3rd. And he's going to pay his accrued charges for the month of July by July 18th. And that total will be $1,085. That's going to prevent him getting filed on and incurring another set of court costs.
Do you agree to those terms, Mr. Schoenerath?
Yes, Your Honor.
You have to pay $1,000 by June 20th, $1,569.03 by July 3rd, and then your accrued July balance, which would be in the amount of $1,085 by July 18th. Do you agree to that?
Yes, Your Honor, I do agree.
Does he have your permission, Mr. Visconti, to sign your name to a proposed consent judgment?
Mr. Cronenwet, you gave me permission to sign your name, correct?
Yes, I did.
Thank you.
You have 3 business days, since you're unrepresented by a lawyer, to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes, Your Honor, I understand.
Any questions at all?
No, Your Honor.
Okay, you're all set. Thank you very much. And then you have Marian Manor versus LaJacquille Peterson, 2502050.
Robert Visconti for the plaintiff.
Sir, your name?
LaJacquille Peterson.
Okay. Any resolution?
Yes, Your Honor. We have a proposed consent judgment as it applies to Mr. Peterson. I'd ask for a corresponding default as to Ms. Morton, who's not present. It's going to be in a total amount of $291.43. That's a $70 late fee for the month of June, and $221.43 in court costs for a total of $291.43, and that's going to be paid by the 27th.
$291.43 is the total?
Yes, Your Honor.
That includes everything?
That includes everything.
So somehow they must have made a payment you weren't aware of. You told me $1,261.43.
That's correct. There was a payment made last Thursday that I was not aware of.
All right, so $291.43, and the writ date will be on the, I'm sorry.
The 27th, Your Honor.
Writ date will be on the 27th. Does he have your permission to sign your name to a proposed consent judgment incorporating those terms, saying that you owe $291.43? And
yes,
sir, that you'll pay that by the 27th, you said?
Yes, Your Honor.
Okay, you have 3 business days to come in here and fill out a motion to set aside the judgment, 10 days to appeal. You understand that?
Yes, Your Honor.
And again, he has your permission to sign your name to that proposed consent judgment?
Yes, Your Honor.
All right. Anything else? Any questions, Mr. Peterson?
No, sir. You have a beautiful day.
I do wish you well. Thank you very much. Mr. Visconti, is that it for you?
That is it for me, Your Honor. Thank you and have a great day.
Have a great day. Thanks a lot.
Yep.
Okay. Do we have Deerfield out there?
Yes, good morning, Your Honor. Michael Burns.
Good morning. Deerfield Estates versus Brian and Rachel Clark, 2502148. Are the Clarks out there?
They are, Your Honor. But if I may, I do have one that's a Motorola, and I can't.
Who's got the Motorola phone? Whoever it is, you have to. You have to identify yourself on the Motorola phone, wherever that is. I don't see it, Jen.
Mr. Clark is present though.
Motorola, Moto G Play, who are you? You got to identify yourself. Motorola, Moto G Play, 2023. Start your video and tell us your name. If you have to identify yourself on these.
Judge, I'm just going to disconnect him and have him log back in because they're not responding.
No problem. Mr. Clark, where are you? Need your name.
Brian Clark is here.
Where is Rachel?
I do not live with Rachel anymore. We're trying to get her off the title of the house. She hasn't lived there in 6 years.
All right. Just stay right there. So Rachel's not here. Did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
If there's one representing Deerfield, yes.
I'm sorry, I didn't hear you.
If there's the one representing Deerfield Estates, yes, I would, because I didn't get a chance to talk to them yet.
Get closer to the device, please.
Yes, I would, because I haven't talked to the attorney yet.
All right.
I think he wants to talk to the attorney for Deerfield, Your Honor, not Lakeshore.
Okay, so you don't want to talk to a Lakeshore attorney that would be advising you?
Correct.
You just want to speak to the lawyer for the plaintiff?
Yes.
All right. Do you intend to apply for funding?
No.
All right, let me do this. I'm going to put this on the back burner for a second. And then I'm going to have him, as soon as I get through a couple more with him, I'm going to have him come in a breakout room, go into a breakout room and talk with you, okay? If you'll just be patient. Okay. Deerfield versus Katie DeLizio and Donald Cash, 2502149. Cash. DeLizio, they here?
No, Your Honor, I've not had them check in.
Counsel, you can take a default on these.
Yes, Your Honor. Thank you. Whenever the court's ready.
I'm ready.
This would be a default judgment, no money judgment to enter. There's currently a rent to retain of $617.52. Court costs in the total of $231.81 for a total of $849.33. We'd ask for a writ date of June 19th, 2025. Again, no money judgment is entered. To the best of my knowledge, defendants are above the age of 18, are competent individuals, are not members of the military, and the premises were kept in a habitable condition for the duration of the tenancy.
Were you, what are your late fees? They're not exceeding $70 a month, right?
Let me confirm, Your Honor. I know the court has that stipulation. I am checking right now. There is, for the month of April, there was $45 assessed on the 7th, and I'm seeing, no, just $45 a month, Your Honor.
Good enough. Default judgment's entered, 849.33. Writ date will be June the 19th of 25. Deerfield Estates versus Rachel Harris. 2502151. Is Rachel Harris here? There you are. Your
Hi.
Name? Your name?
Rachel Harris.
Good morning. Did you listen to and understand the rights?
Yes.
Do you wish to speak to an attorney from Lakeshore?
No.
Do you intend to apply for funding?
No.
Counsel, identify yourself and tell me the total balance due.
Thank you, Your Honor. Michael Burns, P87855 on behalf of plaintiff. Currently, there's a rent to retain of $1,404.76. Costs in the total of $186.73 for a total of $1,591.49.
Do you agree that you owe that amount, ma'am?
Yes.
When can you pay that?
I was wondering if I can have till the end of the month, June 30th.
You want to go into a breakout room and speak to her?
Yes, Your Honor. I would meet with both individuals.
So we're going to have them go in there and speak to you. And I'm going to take a 5-minute recess. I'm sorry, I need to get off the bench for a minute. And I'll come back. I'll take your two first, and then I'm going to go into Granite and South Glen. And I think that will pretty much be it. But maybe I have some more down there. 5-minute recess. Everybody stay seated, please. I'll tell you what, it's about, I'll be back at 10:15. Thanks.
Ms. Paulette, did you speak with Ms. Ford?
502-148. Counsel? Brian and Rachel Clark, 2502148. Counsel? Are they out of there? Mr. Burns, are you out there?
Yes.
Granite Valley versus Joseph and Heather Daly, 2502160. Mr. and Mrs. Daly, tell me your name. Unmute, tell me your name, please. Got to unmute, bottom left, bottom right, bottom left-hand corner, right?
We found it.
Sorry.
Your name?
Sorry.
It's all right.
Joseph Daly?
Your name, ma'am?
Heather Daly?
Did you two listen to and understand the rights?
Yes.
I need one of you to respond at a time. Mr. Daly?
Yes.
Ms. Daly?
Yeah. Yes.
Either one of you wish to see a lawyer, talk to a lawyer. Mr. Daly?
No.
Mrs. Daly?
No.
Do either one of you intend to apply for funding?
No.
Mr. Burns, where are you? Oh, jeez.
Your Honor, I believe he's in a breakout room.
Well, get him out, will you? Please.
Jen, you would have to do that. I can't bring him out.
Oh, that's okay. Well, you know what? I don't know what else to do here.
Judge, Mr. Sprinkle is back. We're ready to set a trial date on that one.
Hidden Gardens versus Sprinkle, 2501951. Mr. Sprinkle, your name? Where is Mr. Sprinkle? I just saw him. I know, but
he's muted.
You have to come in the courtroom, Mr. Sprinkle.
I'll go right.
I'm right here.
Your name?
Wesley Sprinkle.
Ms. Kingsley, your name?
Brianna Kingsley for the plaintiff. Judge, Mr.
Resolution.
No resolution. Mr. Sprinkle wants to proceed to trial. I would like an opportunity to file a motion for summary disposition first.
Okay. Jennifer, I need a date.
Are we going to go into July for that SD motion?
We're going to have to.
Okay.
Yeah.
So
do you have anything the second full week, the week of the 14th?
we have the 7th or the 14th.
I'll take the 14th.
Judge, if we could do that at 10.
So this is going to be July 14th at 10?
By Zoom for the MSD?
Is that what you want on July 14th?
Yes, I can get the MSD out probably within the next week or so, and then he'll have
Right.
21 days to
All
respond.
right, give me a date for the trial. So I'm going to give you 2 dates, Mr. Sprinkle. Why are you walking around? Why do people walk?
I am sorry.
He's in the building, Judge.
I know, but I don't need everybody walking around. It just, Mr. Sprinkle, I'm going to set a motion for summary disposition date on July 14th at 10. We're going to set a trial date for end of July, Jennifer.
The 28th, 2 weeks later,
At
10 o'clock again.
10 a.m. So, sir, they'll give you the notices down there. I wish you well. You might want to consult with a lawyer. It's tough to beat these lawyers. They've been practicing law for a long time. Okay?
Okay, thank you, sir.
Wish you well. Thank you. Granite Valley versus Joseph and Heather Daly, 2502160. Thanks, Ms. Kingsley. Mr. Burns, your name?
Good morning, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Mr. and Mrs. Daly, your name again?
Joseph Daly.
Heather Daly.
Counsel, I didn't know you weren't in here, and I called the case and I explained went through the rights. They indicate they understood them. They don't want to speak to a lawyer, and they're not applying for funding. Do you want to tell me what the balance is that's due, total balance?
Yes, Your Honor. Rent to retain is $1,928.16. Cost in the total of $231.12 for a total of $2,159.28.
And late fees are limited, capped at 70 a month, right?
I am checking right now, Your Honor. Late fees are $35 a month, Your Honor.
Okay. Do you agree that you owe that amount, Mr. and Mrs. Daly? Mr. Daly?
Yes.
Ms. Daly?
Yeah.
Can you pay that amount, Mr. and Mrs. Daly? Tell me, Mr. Daly.
At this moment, no. If I could make weekly payments, I could definitely get it paid off as fast as I could.
Mr. Burns?
How much are you proposing per week and how long is it going to take?
If I could do at least 300 a week, and if I can do more that week, I'll definitely do more. And I could do it with an automatic money order directly to the office.
I'm going to let you guys go into a breakout room and talk, okay? Just stay patient. I'm going to go on to his other cases, then he's going to come in and talk to you, please. Granite Valley versus Maximilian Emery Sharp and Cassandra Leon Orgeck, 2502163. Are they here? Sharp and Orgeck.
No, Your Honor.
Default judgment, counsel, if you want it.
Yep. Thank you, Your Honor. Rent to retain is $1,494.42. Cost in the total of $231.12 for a total of $1,725.54. No money judgment would be entered. We'd ask for a writ date of June 19th, 2025. To the best of my knowledge, the defendants are above the age of 18, are competent, are not members of the military, and the premises were kept in a habitable condition for the duration of the tenancy.
Defendants failed to appear. Default judgment entered. 172554 will be the amount to be paid to save it. The 19th of June is the writ date. Granite Valley versus Shannon Allen Woolsey, 2502164. Is Shannon Woolsey here? There you are. Your name, ma'am? You have to unmute and state your name.
My name's Jessica Woolsey, but Shannon Woolsey's also here.
Yeah, I'm here. She's got to step up there. I got to have her state her name. Where's Shannon Woolsey? I got to see your face, ma'am. I got to see your face, and you got to be in front of the camera.
Am I not here?
Your Honor, I do see a Shannon Woolsey. It looks like he has a bad connection, Your Honor. He's moving around.
Bad connection.
Hang on. Slow down. Stop, Mr. Woolsey. Stop walking around, please. Tell me your name.
Shannon Woolsey.
Stay right there. I'm getting a good connection. Don't walk around. Okay? Did you listen? And Mrs. Woolsey are you Mrs. Woolsey? What's your name?
Yeah, it's Jessica Woolsey. Woolsey. All
right. Only Shannon is an occupant, or are you an occupant too?
He currently.
I was the first day.
I cannot hear anybody here. I'm getting a little frustrated. Forgive me. It's been a long docket. I need you guys to stay close to the.
Shannon no longer lives in the home. We are married.
All right, here's what I'm doing. I can't hear you guys. I'm adjourning this 1 week. You're going to have to come here in person, June 16th, 8:30 in the morning. June 16th at 8:30. Defendants to appear in person, okay?
Your Honor.
Okay.
You have to appear in person, June 16th. Thank you. Granite Valley versus Roy Quillen, Melissa Quillen, 2501791.
Good morning, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Did I just leave?
Roy Quillen, your name.
Roy Quillen.
Where is Melissa?
My wife has passed.
Oh, geez, I'm sorry. I'm really sorry.
She passed in January.
Okay, I'm very sorry about that. We adjourned this until today because he wanted to speak to a lawyer. What is the total balance due?
Your Honor, this is not a non-payment. This is a termination of tenancy for violation of community guidelines. Yes, Your Honor.
Do you intend to contest this or do you wish to leave, sir?
I want to contest it. I'd like to take a trial.
What is the allegations, counsel?
Your Honor, the gist is this. Mr. Quillen has an individual who's living with him who was evicted from the community some time back. She moved in with Mr. Quillen. The community provided notice to Mr. Quillen that he has an unregistered tenant living with him. Mr. Quillen and I have spoken several times. The community has a policy of not allowing evicted tenants to become registered tenants. And he is not intent on allowing this woman to leave. He wants to have her continue living there. I spoke at some length with Mr. Quillen on Friday. We could not agree to a resolution, and the community at this point is not interested in having this formerly evicted individual continue living in their community for many reasons. And so if Mr. Quillen's not willing to have her leave, the community wants both of them out, unfortunately. And to Mr. Quillen's point about a jury trial or a trial of any sort, he failed to file a jury demand when the court informed him of his right at the first hearing.
Mr. Quillen, don't interrupt him, okay? Go ahead, Mr. Burns.
So, I mean, that's the long and the short of it, Your Honor. I don't want to, I tried to inform Mr. Quillen about the writ period specifically to this case, and he's really not interested in listening. And so we can proceed however the court wishes.
Okay, I'll just set it for trial then.
Okay.
You going to be able to represent yourself though, sir?
Well, I'm trying to get a lawyer. I called several lawyers. I was waiting for them to call
I
me
know,
back.
but the case has been pending. You got to move on this. The case has been going on. You were in here on May 19th, May 29th, and today I'm going to set a trial.
All right. Can I talk for 1 minute? The first time I couldn't make it because the Zoom wasn't working, so you reset it up.
Oh, you were stuck by a train or something, weren't you?
Yeah, that's what I'm saying. Yeah. So that's the only reason why I didn't make it that time. So you reset it up for the last time we
May
talked.
29th.
It's the only second time I talked to you about this case. So I don't know how. Yeah. And I just talked to him and I tried to explain to him what was going on here, but he wouldn't listen to me. He's like, it don't matter. He's like, I even asked him, like, if the lady was still paying her rent at her house, would she be there? He's like, yes.
Listen, I don't want to.
Your Honor, he's misrepresenting. Your Honor, I must object. He's misrepresenting facts to the court.
Hang on. Mr. Quillen, you can't let somebody else in there that's not an approved tenant. I'm just telling you. I'm setting it for trial. You have the right to a trial, but we're going to have the trial quickly. So, Jennifer, you're going to give me a date, please, 3 to 4 weeks out.
We can do June 23rd or July 7th.
What day of the week is July 7th?
It's a Monday.
July 7th at?
Let's do 10:30.
So, sir, if you're going to get a lawyer, you better get it quick. Get him or her quick. July 7th at 10:30. And that's when we'll go to trial on this, okay?
In person, Your Honor, I assume?
Yes, in person.
Thank you, Your Honor.
Thank you.
All right. So where does that leave us now?
I believe that's all of them for Granite Valley, Your Honor. We just have South Glen and then the wrap-ups for Deerfield Estate, Your Honor.
Deerfield versus Brian and Rachel Clark, 2502148. Is that the one?
Yes, Your Honor. And then there's also Miss Harris.
Okay. Mr. Clark, your name?
Brian Clark.
You got to start your video, sir. Mr. Lewis, I'm going to ask you to take your head off.
I'm at work.
What's that?
I can't do my video because I'm at work, and when I want a video.
I'm sorry, I didn't hear you.
Where I work, we're not allowed to do video.
Well, you're going to have to do video. I mean, I don't know what to tell you. I mean, if you got to leave in default, I don't know what to tell you, but I'm not coming there.
I can make this quick, Your Honor. We agreed to a consent judgment as to Mr. Clark, a default as to Mrs. Clark based on service. Parties agreed that the total past due amount of $1,538.05 will be paid on or before June 27, 2025. No money judgment is entered. MCR 4.21J was explained to Mr. Clark, and he gave me permission to sign his name to the consent judgment, Your Honor.
You agree that you owe $1538.05, sir?
What was that?
Do you agree that you owe $1538.05?
Yes.
And Mr. Burns tells me that he's going to go ahead and default Rachel Clark, but you're agreeing to a judgment in favor of the plaintiff and against yourself in that amount, with the understanding that it will be paid on or before the 27th of June. If you don't pay or vacate by that date, you'll be evicted. Do you understand that?
Yes.
And he has your permission to sign your name to the judgment? And do you understand you have 3 business days to come in here and fill out a motion to set aside the judgment and 10 days to appeal?
Yes.
Do you have any questions?
No.
All right, judgment's entered, consent judgment, writ date June 27th. Thank you very much. Rachel Clark, Deerfield versus Rachel Clark, 2502151.
Rachel Harris, Your Honor, I believe.
I'm sorry, Rachel Harris. My apology. Ma'am, your name?
Rachel Harris.
Mr. Burns?
Thank you, Your Honor. Parties agreed to a consent judgment with the terms that defendant will pay $817.40 on or before June 11th, 2025, and the remainder on or before June 27th, 2025. No money judgment is entered. MCR 4.201J was explained to Ms. Harris, and she gave me permission.
I still want to make that the 19th, okay? The initial payment.
Okay, Your Honor.
If she misses, you can't submit a writ, and I don't want to sign a judgment that says that. So, ma'am, do you agree to those terms that you're going to pay the total's $1591.42, right, Mr. Burns?
Yes, Your Honor.
And ma'am, do you understand that you have to pay that amount as follows: $817.40 by June the 19th with the balance by June 27th. And if you miss either one of those payments, you're going to be evicted. Do you understand that?
Yes.
You have 3 business days to come in here and fill out a motion to set aside the judgment since you're unrepresented by a lawyer, and 10 days to appeal. Do you understand that?
Yes.
Again, Mr. Burns has your permission to sign your name to the proposed consent judgment?
Yes.
All right, counsel, do you have any more?
Yes, Your Honor. South Glen. We have one case for South Glen versus Lavender.
Why don't you go and talk to the Dailies? Are they out here on this one, on the signing on record?
Mr. Shen, yeah, the Texas card's out there.
Galosha. Kimberly Marie Galosha. 25T644509A B and 25W835356. All right. Where's this is Trenton. These are Trenton and Woodhaven. What do you have, detective? Where's Trenton?
Call back.
All right. Timothy Lee White, 25B725729. Detective Attard, your name?
Detective Ronald Attard, Brownstown Police.
Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you're giving these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
On November 28, 2024, at approximately 2200 hours at 24560 Joyce Road in Brownstown, Michigan, victim Michelle Paterno arrived at her home and discovered her boyfriend, defendant Timothy Lee White, had damaged property within their home, and he was intoxicated. Defendant White is alleged to have grabbed victim Paterno by the throat with his left hand and her left arm with his right hand and began squeezing, causing victim Paterno pain and difficulty breathing and forcing her into a corner of the hallway while screaming at her. Victim Paterno stated defendant White continued to strangle her with his left hand and moved her into a bedroom, onto a bed, and knocking her to the ground, causing her to injure her back. Victim Paterno stated that defendant White then let go of her, and she told defendant White she was calling the police. Defendant White responded to her by saying, "If you call the police, you will see what happens." Victim Paterno stated defendant White attempted to take her phone from her and prevent her from calling the police, but was unsuccessful. Victim Paterno and defendant White separated after assault, and victim Paterno later went to the Brownstown Police to report this alleged incident. No other parties were present during this incident. Victim Paterno received red marks around her neck and her left arm, which were photographed for evidence. Victim Paterno did not seek out medical treatment for her injuries. Victim Paterno and defendant White had been in a dating relationship for approximately 1.5 years and resided together at the time of this incident. Detective Attard attempted contact with defendant Timothy White to get a statement from him in regards to these allegations, and he has failed to contact me back and does not appear to reside in the state of Michigan anymore. Defendant White does not have any prior criminal convictions.
Based on your sworn testimony, the court finds there's probable cause to believe the crime of assault with intent to do great bodily harm less than murder or by strangulation as well as domestic violence was committed. There's probable cause to believe those crimes were committed by the defendant. I'm going to authorize the issuance of the complaint and warrant, and you are all set. Thank you very much.
Thank you, Your Honor.
Oh, wait a minute. These are just misdemeanors. I don't need them on this. I'm sorry. These aren't. Galosha.
Yes,
Kimberly, you can call me.
Yeah, you don't need them, right?
I'm so sorry. Kimberly Marie Galosha, 25W835356, 25T644509. A and B, Miss Galosha, your name?
Kimberly Marie Galadia, Your Honor.
Where you been? Mr. Shemke, your name?
Yes, good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Where you been?
Dude, Judge, she's in treatment right now in Macomb County. She'll be there at least through June 29th, and then she's being transferred to additional rehab facilities. She said something called the Tri-Camp. I don't know her in date, but her out date is June 29th.
All right, so we have 2 cases out of Trenton. Loitering where drugs are kept and open intox, and then we have another one out of Trenton, possession of drug paraphernalia. On all those cases, does she stand mute and waive formal reading of the complaint and warrant?
Yes, Your Honor.
All right. Ma'am, you got to show up. You understand what I'm saying? Where's she in treatment, Mr. Shemke, did you say? I'm sorry.
She's at a place called Tri-Camp through Monroe County.
All right, let me check something here. All right, here's what I'll do. Lisa, can you tell if she's been printed? I don't know where the criminal history is right now.
She was printed on one, I believe.
Which one, the Trenton or Woodhaven?
Let me check real quick. Hold on. It was the Trenton.
All right, so that's the drug paraphernalia and the open intox. So, counsel, anything you want to say? I'm going to give her a personal bond if that helps you.
Your Honor, just that she's trying to put her right foot forward, and I believe that she's going to be dedicated to her rehabilitation. So we appreciate the consideration when determining the bond. Thank you, Judge.
$500 personal bond on the Trenton cases. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. AANA twice a week, but I'll deem that to be satisfied while you're in rehab. But when you get out, you got to come in, you got to get a form, you have to go in person, and every time you go, you have to have the form signed. On the Woodhaven case, which again is loitering where drugs are present, I'll do the same thing, $2,500 personal bond. No alcohol, no marijuana, no illegal drugs, AANA twice a week. Just make sure you show up on this, okay, ma'am?
Yes, sir.
Now, do you still live? I know you're in treatment, but do you still live on Ostrander?
No, I'm on Whitehorn in Romulus.
Slow down a second. Give me a minute. All right. Give me your address. I'm writing it on the Woodhaven case, Lisa.
89 78
Good.
Whitehorn.
Whitehorn, is that the same word?
Yes, sir.
Whitehorn?
That is correct.
Romulus, zip?
Yep, 48174.
Okay, so we're gonna give you a court date. And you're gonna come in here then. I'm giving you personal bonds. I'm doing the same thing on the Woodhaven case, except I don't believe she was printed on that. That's what you're telling me, right, Lisa?
That's correct.
So you have to go over to the Woodhaven Police Department to be fingerprinted and photographed. There's not a print order on that case in here, so I'm gonna ask you to print one out, Lisa, and I'll sign it. We're gonna give you court dates, which on Trenton, the Trenton date, what day did you say she's getting out, Mr. Shemke? The
29th.
Yeah. So we're gonna have to go later on Trenton and Woodhaven. When's the, let's start with the Trenton case.
July 17th at 8:30.
July 17th at 8:30. Don't miss, ma'am, okay?
That's
July 17th at 8:30, and then the Woodhaven one, she's still gonna be in, so we're gonna have to give her a later date.
July 9th at 8:30.
July the 9th at 8:30. Is that a Wednesday?
Yes.
All right, that's gotta stay late. I'll talk to you about that later. Ma'am, you're all set. I wish you well.
Thank you very
Good luck.
much, Your Honor.
We'll see you back here then. Thank you very much.
Thank you, Judge.
Thank you.
South Glen versus Eshawn Lavender, 2502165. Did I call that yet?
No, Your Honor.
Is he here?
No, Your Honor.
You want to take a default on this, counsel?
Yes, Your Honor. I'm sorry.
It's all right. Good.
Rent retained is $2,329.40. Cost in the total of $180.85 for a total of $2,510.25. Per the court's protocol, late fees are, I have to do some math, Your Honor. It looks like my client does charge more than the court protocol, $75. So if you don't mind to pass on this matter, I will do so.
No, that's okay. How many months you taking out? 2?
It would be 2, Your Honor. My client charges $160 in late, or I'm sorry, $175 in late fees per month.
What do you mean 170? They charge 175 per month?
They charge a late fee, Your Honor, on the 6th of $50, plus a late fee on the 31st at the end of the month of $5 per day for late payments. So that comes out to $125.
You know, that's ridiculous. How much is the monthly rental rate?
Monthly rental rate, Your Honor, is $1,000, not including other associated fees.
That means you're charging 17.5% interest to be 30 days late. What a racket.
Your Honor, if I may, it looks like the late fee was already assessed for June, so let me calculate the total late fees, and then the court may subtract what it will.
Go ahead.
Your Honor, the case goes back to, actually, I apologize, Your Honor. There has only been since the beginning of May. So since then, there has been late fees of $50, $125, and $50 for 2 months worth of accrued rent, which would bring the total to $225, Your Honor.
So you got to take out 75.
Perfect, Your Honor.
Right?
Yes, Your Honor.
Wait, would you say 225? Okay, you got to take out $85. So that should reduce this to 24.25 25.
One more time, Your Honor. I'm sorry.
24.25. What changes it? 35 or 25?
It would be 25, Your Honor.
24.25 25 is the amount I'm going to give you. You could submit a judgment on that one, okay? Who's here? Are these guys here in the signing on record out of Brownstown?
This officer is. Yes, sir.
Oh, come on up here. We're gonna do all of these? Jeez. How you doing there, officer?
All right, sir. How about yourself?
Not too bad. People against Sean Lee Christian, 25B703048. Your name?
Officer Aguilar from Brownstown Police.
Raise your right hand. Solemnly swear affirm under penalties of perjury the testimony you give in these proceedings will be the whole truth so help you God.
Right.
Okay, go ahead.
So on 11/20/2024 at 9:47 hours, I was dispatched to 19341 Allen Road in Brownstown, Michigan. I spoke to Deanna Coleman, who stated that she had been assaulted by her boyfriend, Jashon Christian. Coleman stated Christian was driving her to work. On the way there, they got into an argument because Coleman did not want to speak with Christian. Christian then proceeded to grab Coleman's head with both hands and headbutt her. Christian then grabbed Coleman's phone and began hitting the car radio after Coleman refused to kiss him goodbye. Christian then dropped the phone and smacked Coleman on the right cheek with an open hand. Coleman believes it was once, but is not completely sure. Coleman's right cheek had slight redness when I spoke with him. I made contact with Christian via telephone later that day. Christian stated that he did not assault Coleman. He also mentioned that they were not even arguing.
Based on your sworn testimony, I have to find the crime. Domestic violence was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint warrant. And I think you said this, but they were in a dating relationship, correct?
Yes, sir.
Terrell Bryant Smith, 25B711-323, your name?
Officer Aguilar with the Brownstown Police
Raise
Department.
your right hand. Solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole truth so help you God.
I do.
Okay, go ahead.
On 9/27/2024 at 12:25 hours, I was dispatched to 25841 Bridgewood Lane, apartment 130 in Brownstown, Michigan. Upon arrival, I spoke with Cynthia Barella, who stated her boyfriend Terrell Smith assaulted her. Barella stated she told Smith that her son was coming over and that upset him. Barella and Smith began to argue in the bedroom. Smith then pushed Barella back onto the bed and took her car/house keys. Smith then grabbed Barella's face with one hand and told him to get out. Barella left the apartment and walked over to a gas station to wait for her son. Barella and Smith have been in a dating relationship for approximately 5 years. There has been multiple incidents of domestic violence throughout the 5 years. Barella was escorted back to her apartment by myself to gather some belongings because she was going to be staying with her son. Barella did not have any visible injuries.
All right, based on your sworn testimony, I find the crime domestic violence was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint and warrant. You've signed it, I'm signing it, and you're all set. Have a good day. Thank you. South Glen, do we have anything on South Glen? That's done. How about, Mr. Burns, how about Dailies? Did we finish that one?
No, Your Honor, but parties agreed to a consent judgment.
Granite versus Joseph and Heather Daly, 2502160. Go ahead.
Thank you,
Appearances?
Your Honor. I'm sorry, Michael Burns, P87855 on behalf of plaintiff, Your Honor.
Names?
Joseph Daly.
Heather Daly.
All right, give me the breakdown.
Thank you, Your Honor. Parties agreed to a consent judgment. Rent to retain is $1,928.16, cost in the total of $231.12 for a total of $2,159.28. Parties agree that this amount will be paid on or before July 14th, 2025. Otherwise, a rate may issue. No money judgment is entered, and MCR 4.201J was explained to the Dalys, and they gave me permission to sign their name to the consent judgment, Your Honor.
Mr. and Mrs. Daly, let's start with you, Mr. Daly. Do you agree that you owe $21.5928?
Yes.
Do you, Ms. Daly?
Yes.
You understand that he's telling me that you guys have agreed to enter into a consent judgment, that you are agreeing that he can sign your name to the proposed consent judgment, and that you will have to pay that pursuant to those terms on or before July 14th. If you don't and you don't vacate, you will be evicted. You understand that, Mr. Daly?
Yes.
Ms. Daly?
Yes.
Yes.
You have 3 business days to come in here and fill out a motion to set aside the judgment. Since you're unrepresented by a lawyer, you have 10 days to appeal. Do you understand that, Mr. Daly?
Yes.
Ms. Daly?
Yeah.
Ms. Daly, any questions, either one of you, Mr. Daly?
No.
Ms. Daly?
No.
I wish you both well. Good luck to you. I wish you well. Really, good luck to you. Thank you. Thank you.
And I think that's everything for me, Your Honor. So thank you. I appreciate the court's time today.
Thanks. Have a good day. Thank you. Do I have a Truman Estates? Do I have that versus Jason Adams up today?
Yes, Your Honor.
What's that up for? 2501680?
It was a motion to set aside judgment.
I'm here on that case, Your Honor.
Your name?
Christopher Asphalt, 53129 on behalf of the plaintiff.
Good morning, sir. Your name?
Jason Adams.
I can't read your motion here. Can you read it to me?
Yes, I apologize, sir. I simply stated that I was trying to work with the landlord. I just needed a little bit more time to get everything worked out. The lawyer and I was not aware of the first case of the first trial, so that my fiance did not inform me that letter came in the mail. So I didn't know. That was our fault. We didn't take care of that as we should have. I just spoke to the lawyer a few minutes ago, presented a option that I believe works for both parties. We're just waiting for final approval.
Go ahead, Mr. Asphalt. What do you have?
Your Honor, the defendant has made a proposed payment plan to get paid in full within, I guess, essentially 14 days. My client is not, I just heard from her, my client is not able to confirm that they can do that. The only thing I can say is, they said it is still a possibility. They have to speak to a manager. So
how about I adjourn it 7 days? Is that good?
Fine, Judge.
Is that good?
Yeah, that's fine. We can do that.
All right. So we'll adjourn it to June 16th at 8:30, and you can continue to talk and hopefully resolve it.
Judge,
okay?
Can we do 10:30? Because that's when their office is here again.
I don't care.
Okay.
10:30.
June 16, 10:30. Thank you.
1 week from today at 10:30. Okay, gentlemen. Thank you very much.
Thank you, sir.
Truman versus Deborah Jacobs, 2502143. Ms. Jacobs, your name?
Deborah Jacobs.
How to start your video, ma'am?
I did.
Did you listen to and understand the rights?
I did.
Do you wish to speak to a lawyer?
No.
Do you intend to apply for funding?
No.
Mr. Asphalt, your appearance?
Christopher Asphalt on behalf of the plaintiff.
Total balance due?
Including all court costs, total balance is $884.17.
Do you agree that you owe that amount, ma'am?
No.
You don't?
Not for this judgment, sir. I paid $1,000 just a few days after I received the judgment. I owe $85 more. They charged me $260 in late fees.
Are you guys doing that? I'm gonna require them to start coming in here.
They do.
Hang on. Hang on. Don't say anything.
Okay.
Are they doing that, Mr. Asphalt?
Are they doing what, Judge?
Charging $260 a month in late fees? Is that what you're telling me, Ms. Jacobs, or was that over several months?
No. That was for 1 month. My total judgment was $1,085.
Are they charging $265 in late fees?
Yeah, Judge, I'm looking at the ledger for Ms. Jacobs, and I see a payment of $1,000 that was made on May 28th. Maybe that's the payment she's referring to. That brought her balance down to $65. Then rent for June was added on June 1st, and that brings her total to the approximately $884 I see that $50 late fee was $150 late fee was charged in May. $190 was.
Hang on. Where are you getting $265, Ms. Jacobs? Come on now.
My total judgment was $1,085 in May. I paid $1,000 on the 28th. He added the other $85 to June's rent, which I have not paid yet. And I am going to pay that, and I am vacating at the 30th of June. That's my last day here.
Slow down.
Okay, that's my last day here, June 30th.
Slow down. I want you two to go into a breakout room and talk about this. I'm going to go on to another case. I'm going to go on to another case. You be patient. I'm going through three more. We're going to bring out Dale Rogers right now. Truman Estates. Just wait, ma'am. I want you to talk to him before you leave. Truman Estates versus Dale Rogers, 2502145. Is he even here, Jennifer?
No, Your Honor, he is not checked in.
Jennifer, default judgment. Go ahead.
Your Honor, I would request entry of a default judgment. There's currently rent to retain in the amount of $940.
Hang on. I want late fees included now.
Actually, Judge, they have not assessed a June late fee.
Well, did they assess a late fee for May?
No, the only rent that's due and owing is for June.
When did they pay the May rent?
Let me. This is for Rogers. All right, Your Honor, they paid $1,300 at the end of May to get it down to zero, and then June rent came on June 1st.
I'm not doing that. You're telling me they got the balance down to zero and you want me to charge May rent? I mean, I'll give you your court costs if that's what you want. Did the money they pay not include court costs?
Yes, that is accurate.
So do you have court fees that you want to ask for now? But I'm not giving you June month if they paid the balance in May.
That's fine, Judge. We will just dismiss this case.
Good. Tell Truman Estates not to do that, please. And I'm telling you, if I find out that they're charging more than $70, you're going to see some angry Irishman up here. You know what I'm saying? I mean, yes. I made this abundantly clear here for 20 years. I raised it by $20 6 months ago or whatever it was. But if they're charging more than $70, they're going to have a real problem with me. I'm going to dismiss this case motion of the plaintiff. And I'm serious. I know you'll check into that. I have a lot of respect for you. I'm not saying it's you, but your client's not going to do that. And they're not going to come in and send a lawyer in here and ask me for a judgment that includes May rent when they already paid by the end of May. I mean, what? They can't do that. Truman Estates versus Cody Kaler, 2502146.
Christopher Asphalt for the plaintiff.
Is Cody Kaler here, Jen?
No, Your Honor, defendant failed to appear.
Go ahead.
Your Honor, I would request entry of a default judgment. There's rent due and owing in the amount of $2,294, a late fee in the amount of $50, court costs in the amount of $184.17 for a total amount of $2,528.17.
Defendant failed to appear. Default judgment is entered. Writ date will be on the 19th. The amount to be paid to save it is $2,528.17. And finally, I have Truman Estates versus John Scheffler, 2502147. Is he here?
No, Your Honor.
Default judgment.
Your Honor, I would request entry of a default judgment. There's rent, $910, late fee, $50, court costs, $184.17 for a total of $1,144.17.
Defendant failed to appear. Default judgment entered. 1144.17 is the amount to be paid to save it. Writ date will be on the 19th. Do you have any more, Mr. Asphalt?
Just the one that you wanted me to meet in the breakout room with.
Yeah, which one was that again?
Mr. Asphalt, I have Red Hawk.
Oh, yes, you're right. I do have Red Hawk versus Lewis.
Mr.
Which
Lewis
was
is
the one
here.
that you were going to meet in the breakout room with
Miss
again?
Jacobs, I have her in room 5.
Good. So wait on that one. I'm going to do Red Hawk Landing. That is Red Hawk Landing versus Dwayne and Evelyn Lewis, 2502166. Good morning, Mr. Lewis. How are you? Your name, please? You have to unmute, sir. Mr. Lewis, you have to unmute and state your name and put the camera in your face, please.
Unmute. How about that?
I gotta see your face now, sir.
Okay. I'm trying to get it to. Unmute. Okay, perfectly fine. Oh, the other camera came on. I wonder why you do that.
Mute him, Jennifer.
Yeah, I'm at the turn this way.
Mr. Lewis he's on the screen now.
On the screen.
Mr. Lewis, your name?
Your Honor.
I need your name.
Beg your pardon, Your Honor. Dwayne Lewis.
Did you listen to and understand the rights?
Yes, Your Honor.
Do you wish to speak to a lawyer?
Yes, Your Honor. No, Your Honor.
You don't wish to speak to a lawyer, or you do?
I didn't hear that, Your Honor. It's breaking up.
I know. Where are you at? What city are you in right now?
Well, I'm in Brownstown.
Well, next time you come,
I'm parked on the side.
Next time you come here, all right? Do you want to speak to a lawyer?
It depends. I think I don't want to speak to a lawyer, but my mother may need a lawyer.
I don't need a lawyer.
Because, Your Honor, I have moved since April.
All right, here's what I'm doing. Here's what I'm doing. I'm adjourning this 1 week. Your mother has to be here June the 16th. What time, Jen?
That would be 10:30.
At 10:30. And if you or her want to talk to a lawyer, we will set you up with a lawyer to speak to. Okay? So just stay right here. She'll put you in a breakout room, but you have to be in person next time, okay? In person, not by Zoom, all right? In person. Thank you. See you next week at 10:30, in person. Have to show up in person. Thank you. N&D Properties.
No.
Versus Kelly Sizemore, 2502155. Good morning, Mr. Joseph, your appearance.
Good morning, Judge. Joe Joseph for plaintiff.
Kelly Sizemore here.
Has not appeared, Your Honor.
Come on up.
Sorry, I wasn't aware she was in the courtroom.
Ma'am, you can have a seat right there if you'd like. Yeah, if you want to. How you doing?
Real good. Oh,
Your name?
Kelly Sizemore.
Did you listen to and understand the rights on the video?
Judge, I was not aware she was here, so she did not get to see the video.
Ma'am, you have the right to a lawyer. You can have a seat. You have the right to a lawyer. You have the right to proper venue. You have the right to demand a jury trial within 5 days. You have the right to apply for funding. There's a possibility of conditional dismissal if all parties agree. And if you want to speak to a lawyer, I'm going to set you up with a lawyer on Zoom right now, or at least information. So first of all, do you understand all those rights that I mentioned?
Yes, Your Honor.
You wish to speak to a lawyer?
Yes, Your Honor.
We're going to set you up to speak with a lawyer. I'm going to adjourn this 1 week to June 16th. At what time? 10:30?
9:00.
At 9:00. June 16th at 9:00. You go down the hall and they'll tell you how to get a hold of Lakeshore. I think that's the best way to do it, Jen. And we'll go from there, okay? And then you have to, and you show up next week at that time, okay?
Yes, sir. Thank you.
Best of luck to you.
I appreciate it.
You're welcome. South Point versus his lady Galindo. 2501965. Is she here?
Your Honor, she was here. I don't have her here now. I think she was in a breakout room to speak with counsel, possibly.
Did she go in there and speak with you, counsel?
She did, Judge, and we did reach a resolution, which I'm happy to place on the record. I don't know why she left, but we did speak.
I don't know. Well, I mean, I guess I could take a default in accordance with your terms of your consent judgment if you want to do that. Or was that a conditional dismissal?
You know, it was a consent, and I'm happy to place those terms on the record. I mean,
or do you want me to adjourn it a week and you can send it to her and ask her to send it back? I really need to cover that if it's a consent judgment on the record anyway.
Right. We can do it by default. That's fine. It'll be the same term, so it's not going to change.
Go ahead.
Thank you, Judge. As indicated, we did speak in the breakout room and reached a resolution for a consent judgment, which I now understand will be by default based on her having signed out. The rent retained judge is $2,133.39, and the court costs are $179. That totals $2,312.39. We were using the writ date of June 19th. I'm not sure if the court is closed on the 19th. If so, we can bump it to the 20th.
Are we closed the 19th, Jen?
Yes, Your Honor.
That's when Juneteenth is being
observed, and I didn't catch that today.
Yeah.
This year's gone so fast already.
Okay, so writ date will be June the 20th. I know it has. It's crazy. All right, so we can do that then. Make the writ date June 20th, if you will.
All right, Judge, we can submit that by default.
And they're not charging more than $70 a month, right?
Correct. Right. That's the late fee. Well, I think it's slightly more, but we adjusted it. So
you've limited it to 70 a person, right?
Correct. Yeah, 70 per month.
Thanks a lot.
All right. Thanks, Judge. Have a good day.
Thank you. You too. Iqbal Amir versus Daniel Marvin Delshoni and Jeanette Cricks. Gil 2502004. Where's Mr. Iqbal? I'm sorry, Iqbal Amir.
He's muted. He's on Zoom.
Mr. Iqbal, you have to show up on Zoom, please. Or Mr. Amir, I'm sorry. Okay, sir, your name? You have to unmute. Unmute, bottom left-hand corner.
Now it's okay?
Yeah, your name?
Amir Iqbal.
I don't know why we adjourned this before. I think it's because you didn't pay for a second mailing, right?
That's correct, Your Honor.
So you can go ahead and take a default. Neither one of them are here, right, Jen?
Yes, Your Honor, no one appeared. They were sent notice to appear in person.
Tell me how much they owe in past due rent, sir.
I think they due like $1,850.
All right, well, I don't want you to think. I want you to know. Are you sure they owe you $1,850 in past due rent?
Yes, because they didn't pay for month rent and the late fees for $50.
All right. What else do they owe you besides $1,850?
I know nothing else beside that.
Did you include your filing and service fee and all that?
No.
How much does he have in that? It looks like he has two service fees worth $70.75.
And a filing of $55.
Right. So he's got $125.75 on top of that. So it should be $1975.75.
Yes. Mm-hmm.
And I'll tell you what, they didn't show up. Do I have a default judgment here? I'm just going to fill out the judgment for you. Okay. You all right with that?
Sure.
June the 20th will be your writ date. I can't believe we missed that all day long. You may be liable for money damages after moving if additional rent is owed or there's damage to the property. An acceptance of partial payment will not prevent the court from issuing an order of eviction. He did not pay for a money judgment. Is that true?
That is correct. The filing was only 55.
So no money judgment is entered at this time, sir, okay? I've got the judgment filled out. We'll send it over to them. And if they don't pay up or vacate by June 20th, you should come in here with an application for a writ on the 23rd, which is a Monday, okay?
Okay, sir.
I wish you well. Any questions?
I have one question. My neighbor said they saw the U-Haul. So, I mean, I don't know, they abandoned the house or I don't know.
You cannot go in until they turn over the keys or you get a writ of eviction.
I got it.
So don't go in there. You could get yourself in all kinds of trouble, okay?
I got it.
All right, good luck. Thanks. Do we have another file on there? I have no other case down here as far as I can tell.
Judge, there should have been 2 packets in with Mr. Iqbal's. There should have been Mr. Pittaway's should have been in there as well, unless the paper clips got caught.
You're right. Donald Pittaway versus Ronald Pittaway, 2502023.
Yes, Your Honor. I'm Donald Pittaway. If you can hear me.
I can. Your name? Were you here on June 2nd? No.
No, nobody gave me a notification. He sent something to my legal address. He sent it to ended up at my brother's house.
Did you listen? What is your relationship here?
He's my older brother.
Do you have a written lease agreement with him, Mr. Pittaway?
No, he moved out and assumed another residency, leaving his property behind, and I want that property out of my garage.
What kind of property?
Furniture.
Hey, you guys get along? Do you guys get along?
Sometimes.
Well, I know, but this is ridiculous.
This is ridiculous because he doesn't
Slow
own the
down.
house. He doesn't own the house, sir.
Who owns the house?
My dad. My dad's 85.
Does your dad own the house?
Yes, he does, but I have power of attorney to handle all matters.
You're going to have to talk to a lawyer. I can't let you appear for your father in a courtroom. And what's his name?
Same name, and I can get him in about 2 minutes and stuff, and he can sit down in this chair and you can talk to him if you'd like to.
Yeah, but you're filling out the paperwork. Are you the second or the third or the junior or what?
You can call me junior and he is senior, but technically there is no second designation on my birth certificate. Not gone by either the second or junior, either way, my whole life.
Is he senior?
Yes.
He's the second.
Who is?
My brother.
You're the second and he's a senior?
Nah.
Yes.
Yeah, my dad first. And
How old are
second.
you? How old are you?
Me, I'm 53.
How old are you?
56.
You guys can't just work this out. Are you kidding me?
He's trying to steal my stuff.
Hang on a second. Wait. Whoa. How many brothers you got, Mr. Donald Pittaway?
Including me, I have 3 other brothers.
What do you want him to do?
I want him to get his stuff and leave because we have police reports for malicious destruction of property I hold right in front of me, as well as the police officers have advised me to get a personal protection order.
All right, Mr. Pittaway, here's the problem. You filled out the paperwork and you really can't do that.
Okay.
Okay?
Hang on. I'm going to adjourn this. I'll either adjourn it for a week or 2 weeks and let you talk to a lawyer. Yes, sir.
And the lawyer will explain how to go about this. Okay, I'll adjourn it just for 1 week now. If you need another one, I will. We're going to adjourn this to June 16th at what time?
10 o'clock.
At 10 o'clock. I would like to think you guys could get along and take care of this, but you can't represent your father, sir.
I understand.
Okay? You just can't do it. What's in the garage?
Furniture, motorcycle, hockey equipment.
Who says that?
It says it's his, and he's storing his friend's stuff in our garage as well.
I don't want to argue about it or talk about it. Listen to me very carefully. Hang on a second. You guys should be able to sit down and work this out like men.
Absolutely.
All right, but you sound like a couple of 9-year-olds, if you want my honest
I would
opinion.
have never entered in court if it was up to me. I got 30,000.
I don't want to hear it. I'm adjourning it a week. I'd like to think that you two are mature enough to work this out. You just said he's trying to steal your stuff. He just told me he wants it out of the garage. Hang on. And he doesn't own the property, and his dad does. He can't come into court with a power of attorney. So you guys can make this as complex as you want to, but I'm going to insist that you do it right. I'm adjourning it 1 week until 10 a.m. next week, and you guys can figure it out. You can get a lawyer, and we'll go from there. Thank you very much. Have a good day. In person. I don't know who he is, but
It's his motorcycle.
he has nothing to say about anything right now. He's not even a party. Right?
Well, we don't know what happened to the motorcycle. He just wanted to get it. He moved his.
That's not before the court. I'm not going to take up issues that aren't before the court. If you guys can't be mature enough to resolve this, then you can all go get lawyers and spend thousands of dollars on lawyers if you want to. And that's okay. He's gone or he's here, but I'm not addressing it. I don't have one thing to do with any of this stuff. All I know is he's brought an action, and his action isn't very well brought because he can't represent your father, and he can't evict or do anything else on a house that he doesn't own. Guys, I'll see you then. Thank you. What other case do I have down there? What do you have, Mr. Asphalt?
Yeah, Truman Estates versus Jacobs.
I need that file. Truman Estates versus Jacobs. Did you already take it down, the Truman Estate ones?
I might have, if you put it on the thing.
I know, I probably did. My fault again. I'll need that back. Concord versus Loretta Goings, 2501817. I think the file got taken down, Mr. Asphalt.
I don't have it, Judge, at least in what I was given.
You what?
I don't have the Truman Estates file.
All right. I probably threw it in the garbage. I don't know what I did with it. It's around here somewhere. Just give me a second, Ms. Jacobs. Mr. Mayers, good morning. How are you?
Good morning, Your Honor. How are you doing?
Doing all right. Soon getting on my nerves again today.
You take it easy, Judge.
How you doing?
I'm doing great. I got a 1:30 tea time.
Good. Well, I'll get you out of here then. Your name?
Ralph Mayers, P23815, appearing on behalf of the plaintiff Concord Co-op.
Yeah, of course you can. What's your name? Did you two talk?
Not today.
How much is owed? Can you just tell me the total amount?
Yes, Your Honor. The total amount would be, hold on a second. Here we go. Okay, here we go. Got it. Amount due in monthly carrying charges, Your Honor, is $2,087.66.
Mr. Mayers, did you speak to the
Wait. Go ahead. What else do you have?
Cost of $104.93. Total due $2,192.59.
$2,192.59?
Yes.
You agree that you owe that?
No.
What do you owe?
I dropped a money order off on Friday for $800. The
So-
last time I spoke to Mr. Mayers, my balance was $1,200. I dropped the money order off for $800, so.
So you owe
it's for in
$13.92.
June.
So you owe $13.92.59?
That sounds more.
She says she dropped off a money order on Friday for $800.
Your Honor, I just read a note from the office this morning. They notified me that $800 was paid over the weekend. So we're taking that off of the 2,087.66. So the balance now is only 1,287.66. Just got that message.
Okay. Do you agree that you owe that?
Yes.
All right. Can you pay that, ma'am?
I can have it paid until by the 20th.
Can you live with that, Mr. Mayor? She's saying she can pay it by the 20th.
That's fine, Judge, no problem, and good luck to Ms. Goins.
You want to do that by a consent judgment or after hearing?
I think it would be a consent judgment, and again, is that writ date June 20th?
If you want to agree to a consent judgment and you want to give him your permission to sign your name to that, he will insert in the proposed judgment that you owe $1287.66, and the writ date's June the 20th. Do you want to agree to that?
Yeah,
And does he have your permission to sign your name to that?
that's fine.
And since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You also have 10 days to appeal this. Do you understand that? Do you have any questions?
No.
All right.
I guess I do. The end of the business day on the 20th, correct? Is that how that works for the writ to be issued?
Why, you going to be cutting it close with
No,
that?
just because the 19th is a holiday. I shouldn't have it issued because I do have direct deposit, but just on the off chance. I
Yeah.
just want to make sure.
What time's the office close? 4:30?
Usually 4:30, maybe 5 at the latest, but 4:30 is good.
So make sure you get it over there try to get it over there before 4, okay?
Okay.
All right. Anything else? Okay. He's going to submit the paperwork, sign your name as we talked about. I'll sign it and you'll get it by the end of the week anyways. Just make sure you make that payment by then.
All right, no problem.
Best of luck to you.
Thank you.
Truman Estates versus Deborah Jacobs. 25021. Oh, wait a minute. I got one more, don't I, Mr. Mayers? I'm sorry. Concord versus Joliza, Canada. 2501817. Is she here, Jen?
No, Your Honor.
Default, I'll take on this one.
Okay, Your Honor, Ralph Mayers 23815 on behalf of the plaintiff. And yeah, since she hasn't appeared at either hearing, we would move for a default judgment. I have the amount due and owing when you're ready.
Okay.
$1,609.24 in monthly carrying charges, $104.93 in court costs, a total proposed judgment of $1,714.17.
Defendant failed to appear. Default judgment's entered. Writ date will be on the 20th. The amount to be paid to save it, $1,714.17. Mr. Mayers, nice to see you. Take care.
Same to you, Judge. Thanks for your help and your
Thanks a lot.
Expediency so I can have the afternoon. Thanks a lot.
Go enjoy yourself. Take care.
Take care. I will. Thank you.
I hope you're golfing better than I am. Truman versus Deborah Jacobs, 2502143.
Christopher Asphalt for the plaintiff.
Your name, ma'am?
Deborah Jacobs.
Any resolution on this, Mr. Asphalt?
No resolution, Your Honor, but just briefly. So after the May charges were assessed, she owed $875. She then made a $1,000 payment at the end of May, giving her a rent credit of $125. At that time, court costs in the amount of $184 were assessed, leaving her a balance in May of $59. Now June rent has been assessed, and the balance is $884.
Ma'am, what do you want to say?
Well, sir, his figures aren't right, but I will pay the $840 or $884. I am leaving here after 17 years with no considerations. So I will pay the $884?
Yes.
I will pay that on the 28th, which is my next check, and I will be out of here by the 29th. I will pay the rent.
All right. Okay. Okay. Do you agree that you owe $884.12 or not?
Well, yeah, with the $50 fee and whatever he's saying, my rent is $825. So yeah, go. That's fine. I just want it settled, and because but he does charge $240 overcharges.
What do you mean, ma'am?
He does. That's what he charged.
What you mean by overcharges? Rent or late fees?
Yes.
Have they done that, Mr. Asfalk?
No, the late fees are $50, Your Honor.
He's saying the late fees are $50 a month.
That's not true. I got my rent was $825. I got a $50 the original late fee, and then I was charged $220. Well, it totaled $1,065.
Because the court costs, though, ma'am. That's not because of late fees.
Well, no, he'll charge me court costs again. I've dealt with this man for 17 years. He's going to try to charge me for more court costs. So if I can get a final judgment of the $884, I will pay it on the 28th of this month. I will turn in the keys and I will be gone.
All right. I'm going to just do this after hearing. Judgment for plaintiff after hearing. $884.12. Pay in the writ date. I'm going to make June the 30. Okay. Writ date will be June the 30. That's a Monday. Okay.
All right. Thank you, sir.
Your Honor, just for the record, I'm going to object. That's beyond the 10 days of June 19. And I also just wanted to clarify. So the total amount due and owing is $884.17.
And 17 cents. I understand.
With a writ to issue of June 30th. I will present that to the court.
Thank you very much, Mr. Asfalk. Ma'am, thank you very much. Good luck. Thank you.
Thank you.
I believe that's all my cases, now? Judge.
Thanks a lot. Thank you. Wow.
Miss Paulette, we're all set.
I'm telling you.
Thank you.